The three-judge panel established by the Tennessee General Assembly and selected by the Tennessee Supreme Court for this particular case will now transact the business for which it was created. All persons having business before the court, draw near, give attention, and you shall be heard. God save the United States, the great state of Tennessee, and this honorable court. The Honorable Ann C. Martin, Mark L. Hayes, and Zachary R. Walden presiding. Please be seated and silence all cell phones. We are here in the matter of the Metropolitan Government of Nashville and Davidson County, Tennessee versus Bill Lee et al.
Good afternoon. Nice to see everyone. I'm Chancellor Ann Martin. I am the presiding judge, which really means my court is where this case was originally filed. With me is Judge Mark Hayes, who's here from the 29th Judicial District in Dyersburg from West Tennessee, and Zach Walden from the 8th Judicial District from Jacksburg in East Tennessee. Before we get started with argument, we want to, for the record, note who is here for each of the parties and have them introduce themselves. So for Metro Government, Mr. Dietz, if you want to introduce yourself and the lawyers who are here with you. And we do not have mics on the council table because we want you all to be able to confer without worrying that you're on a hot mic. So to be picked up for the live stream, it's important that you speak from the podium. Looks like maybe you've already gotten that instruction. Okay.
Thank you, Your Honor. Good morning and good afternoon, and Your Honors. Welcome to Nashville.
Thank you.
I'm Wally Dietz. I am the Law Director for the Metropolitan Government of Nashville and Davidson County. With me is my colleague, Melissa Roberge, from the Metro Legal Department. She will be making our argument this afternoon. With us is Robert Bob Cooper, former Attorney General with Bassberry & Sims. And we have Wes Love, also with Bassberry & Sims, and Michael Doan with Metro Legal. Thank you.
Thank you so much. And on behalf of the state.
Good afternoon, Your Honor. Tim Simons here with the Attorney General's office. I have my co-counsel, Mr. Jonathan Shirley, and Mr. J.P. Urban. We will all be representing the defendants in this cause.
Thank you so much. And on behalf of the Metro Nashville Airport Authority.
Good afternoon, Your Honor. My name is George Cate of the Bradley Law Firm. I'm here on behalf of the Metropolitan Nashville Airport Authority. I have with me my partner, Jim Murphy, who's seated there to my right, and then further to my right is my associate, our associate, Ryan Kilpatrick. Thank you.
Thank you. So what we are going to do today is hear from Metro first, since it's Metro's motion. Then we'll hear from the state. Then we'll hear from the interveners, and then we'll give Metro the last word. We do want you all to know that we appreciate your submissions, which were very thorough. We have all read everything and found them very informative, so we want you to take the time that you need, but I do preface this by saying we have read what you've submitted. So with that, Ms. Roberge, I think you're going to make the argument, so we're ready for you.
Good afternoon, Your Honors. May it please the court, Melissa Roberge on behalf of Metro Nashville. For 53 years, any municipality in this state with a population over 100,000 could form a metropolitan airport authority. These authorities were formed because of the projected rapid growth in air traffic, the need for adequate terminal facilities in the metro regions of the state, the need to eliminate airport hazards regardless of county and city boundaries, and to lessen the burden on taxpayers. And so the big four metropolitan areas created these metropolitan airport authorities: Memphis, Knoxville, Chattanooga, and Nashville. And it wasn't a simple snap of the fingers. Creating these authorities took time, it took deliberation, it took local approval, and the ultimate creation of another tentacle of our governments. Every executive officer and every governing body of a creating municipality appointed every commissioner on their airport authorities. The state didn't have a single appointment. And that's because the metropolitan airport authorities were never intended to be part of the state. Until this year, of course, and only if you're Metro Nashville. In passing the Metro Nashville Airport Authority Transfer Act, the legislature violated the Tennessee Constitution in 3 ways. First, it violated Article 11, Section 9 by enacting a local bill without the required local approval. Second, because the act removes seated commissioners before their term expires, it violates the prohibition on ripper bills. Third, it violates the Equal Protection Clause in Article 11, Section 8, because it irrationally creates a class of one. I'll first begin by briefly describing what the Act does. Section A creates the class, and that class is first an airport authority, second in a county having a metropolitan form of government, third with a population over 500,000, and fourth must have all of these requirements by the dates contained in Section C. After it creates that class, it immediately vacates the board of those airport authorities. Today, that only applies to Metro Nashville. Part C staggers the terms of the new appointments so that they sunset in 2025, 2026, 2027, and 2028. Because the statute has no provision for the initial appointments after Section C sunsets, it also acts as a deadline for when another county or another airport authority could grow into this class. There was a time that the Metro Nashville Airport Authority Transfer Act would have been business as usual, but that time was 70 years ago. Because 70 years ago at the 1953 Constitutional Convention, the relationship between state and local governments fundamentally changed, and it fundamentally changed by the adoption of the Home Rule Amendment. That amendment fundamentally changed the relationship between the General Assembly and Home Rule governments because such entities now derive their power from sources other than the prerogative of the legislature. The primary intent of that amendment was to vest local control in local affairs to the maximum extent possible. The Home Rule Amendment contains 3 clauses, one of which is the Local Legislation Clause, and that is a segue into my first likelihood of success on the merits argument. The Local Legislation Clause has 2 prohibitions, which are in counts 1 and 2 of our amended complaint. The first is the prohibition on ripper bills. The second is the prohibition on acts that are local in form and effect. I'm going to start with the prohibition on acts that are local in form or effect. The Supreme Court clarified in Metro v. TDOE that there are 3 elements when a statute is challenged for being local in form or effect without local approval. The first is that it actually be local in form or effect. The second is that it be applicable to the county. And the third is that it be applicable to the county in its governmental or proprietary capacity. Because the state doesn't challenge the third element, my argument will focus on elements 1 and 2. In determining if an act is local in form or effect, this court is to apply reasonable, rational, and pragmatic rules under Ferris. These aren't theoretical, illusory, or merely possible considerations. And when you apply those considerations, this statute will never apply to another local government. The opinion issued by Judge Hardy Mays is instructive. In Board of Shelby v. Memphis City Board, the court used the well-established rules in both Ferris and Burson in evaluating a home rule challenge. There, the class started with 8 counties with a special school district. Looking at those 8 counties, the court said for it to survive the challenge, there must be more than one that fit into the statute. So the court started with 8, and then it started to apply the conditions contained in the statute, and the class got smaller. And then they applied the next condition, and the class got smaller. And then they applied the third condition, and the class got down to 1, Shelby County. That is the same effect that this act has. We start with metropolitan airport authorities. We add the population threshold on there of 500,000, and now we're down to 2, just Memphis and Nashville. Then we add the form of government, and we're down to 1, just Metro Nashville. And then we add the timing requirements, and we will always be at 1. You won't hear the state suggest that another county or municipality could fit in that doesn't already have a metropolitan airport authority. And here's why. Because that county would need to consolidate its government, have an airport, create a metropolitan airport authority, and it would need to do all of that before the deadline in Section C. That's simply a fiction. And Board of Shelby versus Memphis tells us that when it's fiction, it's unconstitutional. Defendants cite to Burson to try to support that this is a law of general application. Burson regulated any civil service board in any county with a population of 300,000. From the moment the law was applied, it applied to 3 counties. Knox County was the only county that had to take action to come into compliance, but it unquestionably applied already to 3 counties. Here, the act unquestionably only applies to 1. Burson teaches us that the inquiry is about what class is created, and the class created in Burson is distinguishable from the class created here. Burson had a population threshold and then a small carve-out for a mayor-alderman form of government, but that did not significantly narrow the class. But if we contrast that to what's happening here, the inclusion of the form of government limits the class to just 1. An idea that it would apply to another county is a myth. The state points to both Shelby County and Knoxville as it potentially applying there. It matters that no other airport authority has the form of government or meets the population threshold today. And that's because Section 2 doesn't create a standard for what the Board of Airport Authorities and metropolitan governments with a population of 500,000 will look like after 2025. By its language, it only applies for a very short period of time by operations of Section C and D. Section C dictates when the initial appointments expire. After the expiration of those dates, there is no initial appointments to be made. Section D sets subsequent terms after the initial terms in Section C expire. All of the initial terms expire by 2028. That directly affects if it's reasonable that another county will grow into that class. It's not reasonable that Shelby and the city of Memphis will consolidate in 2 years. They've tried 3 times before and failed, and there are no efforts currently underway to consolidate. Similarly, it's not reasonable that that would happen in Hamilton or Knoxville.
Actually, isn't it impossible in Hamilton or Knoxville? The way the legislation's written specifically talks about population of the 2020 census or any subsequent census. There won't be another census until 2030.
Exactly. So even if Hamilton and Knoxville consolidated, they wouldn't meet the required population threshold.
They're precluded for probably about 8 or 9 years, right?
Correct. A separate 3-judge panel of this court found that the timing requirements indicated that the statute was local in form or effect. And that was in the lawsuit that Metro brought to challenge the Metro Council Reduction Act. There, the statute dictated that just one planning department start redistricting within 30 days. Didn't make any provision for what happened after that. The court found that Metro was likely to succeed on the merits and enjoin the law. There's a pattern here. The state is so eager to target Nashville that it draws these boxes specifically around Nashville. The Tennessee Constitution says that the legislature can't do that. Based on the supplemental authority filed yesterday, it's anticipated that the state will argue that some part of Section 2 should be severed. As pointed out by MNAA in their brief, the severability clause in the Act is designed to apply to Sections 3 through 9. It's not designed to rewrite Section 2. Moreover, applying the doctrine of elision to Section 2 is completely unworkable. The legislative intent of that section is that it applies only to Metro. And there's no modification, addition, or subtraction within this sentence that would, within that section that would change that. The provisions of Section 2 are interwoven statutory mechanics. First, it creates the class, then it vacates the board, Then it has the initial appointments, and subsequent appointments are keyed off of those initial appointments. You can't eliminate Section C completely, because then you wouldn't have the staggered terms or any time frame at all for the initial appointment. Essentially, this court would have to keep going and going and going to make this statute anything other than what it is, which is a local bill that applies directly to Nashville. It's not this court's job to be an editor of the legislature's work. It's the adjudicator. The state argues that the act isn't applicable to Metro Nashville because it doesn't regulate its conduct. It argues that it regulates metropolitan airport authorities, but that's a bit of a bait and switch because it points to sections 3 through 9, and that does govern the conduct of metropolitan Nashville airport authorities. But section 2 governs the conduct of the mayor and the council. Before section 2, the mayor appointed and the city council approved every commissioner on the Metropolitan Nashville Airport Authority Board. Then section 2 gets passed and that's all changed. Now, under section A of section 2, the Nashville mayor only has 2 out of 8 appointments. The other appointments go to state officials. It further regulates the conduct of the mayor by saying what those qualifications must be for those appointments. 1 must be from Nashville and 1 must be from a contiguous county. Metro v. TDOE sets forth what it means to be applicable to. On its face, the statute must regulate the conduct of the county. On its face, the Nashville Airport Authority Transfer Act regulates the conduct of the mayor. If directing the actions of the executive and the legislative body is not regulating the county, what does? Absolutely nothing. And we know that that cannot be the result. Because this act specifically regulates only Metro Nashville and will only ever regulate Metro Nashville, it violates the local legislation clause, and that is a reason to enjoin the statute. Turning next to the prohibition on ripper bills, this operates as an independent basis for this court to grant the injunction. As we've established, the Nashville Airport Authority Transfer Act is local in form or effect. The state does not contest that it removes the MNAA commissioners from their appointments before their terms ended. The state does raise a standing challenge, arguing that Metro Nashville is asserting the rights of the commissioners. We are not asserting the rights of the commissioners. We are asserting our right to have our appointees serve their entire terms. The interest protected by the local legislation clause is local control over local affairs, and the state has interfered with that interest by removing our control of the Metropolitan Nashville Airport Authority. The Tennessee Court of Appeals uses the following definition to define a public officer: an incumbent of a public office and an individual who has been appointed or elected in a manner prescribed by law, who has a designation or title given him by the law, and who exercises the functions concerning the public assigned to him. The MNAA board members easily satisfy that test. And again, the state doesn't contest that they are public officials. But the question is, who are they public officials of? Are they public officials of the county? The state points to cases that focuses on MNA's status as an independent legal entity. I want to be very clear. We are not disputing that. But those cases simply don't answer the question. The state is trying to read out the language in Tennessee Code Annotated 42.4.102. And that language states, "It is declared that airport authorities created pursuant to this chapter shall be public and governmental bodies, acting as agencies and instrumentalities of the creating and participating municipalities." And Your Honor, when we were doing additional research, we came across 3 prior public acts that modified 42.4.105, if I can pass these up. that is what's being handed up is the 1987 version of the statute, the 1990 Public Acts 1080, 1988 Public Acts 887, and 1988 Public Acts 909. In each of those cases, the legislature was tinkering with the composition of the airport authority boards by changing the qualifications for board members. It included a subsection in each of those public acts to ensure that no terms of board members were abridged. Without Section 3 and all of those public acts, the bill's mandatory languages would have required that the positions be filled immediately with someone who met the new qualifications, even if those positions were currently filled by someone else. Stated differently, Section 3 in each of those public acts prevented these acts from becoming unconstitutional ripper bills. At a minimum, this is a clue that when the Metro Airport Authorities Act kept the relationship between the county government and the airport authorities by making the airport authority an agency or instrumentality, that it intended for those board members to be county officials. We also have the Constitutional Convention's intent of local control over local affairs. There is nothing more local than controlling who is on your airport authority's board. And shortly after that becomes enshrined in our Constitution, that is when the airport authority boards is passed. Importantly, it's not passed with state membership, it's passed only with local membership. Because officials of an agency or instrumentality of their government are public officials, the prohibitions of the Ripper Bill apply, and this Section 2 is also unconstitutional for that independent reason.
Council, does the anti-Ripper section also have to be local in form and effect?
It does.
So if the acts that you passed up applied to every airport authority statewide, then that's really a courtesy to the people on the board. It still wouldn't be a Ripper Bill if they had removed them, because it would still apply to all 4 airport authorities.
So the provision that was amending was specific to metropolitan government
Okay.
airport authorities. But
Thanks for that clarification.
You're welcome. Moving on to the equal protection claim. Again, the state makes a standing challenge, and again, it's futile. Burson establishes that cities have equal protection rights under the Tennessee Constitution, and while that cites one equal protection clause in the Tennessee Constitution, it cites White v. Davidson County. And White v. Davidson County, which is a Tennessee Supreme Court case, holds unequivocally that cities and counties have equal protection rights under the Tennessee Constitution. The legislature made no secret that this act was written specifically for Metro Nashville, stating it so plainly that this legislation only relates to this particular airport with this particular situation. During their session, they offered 2 different rationales, both of which are easily dispensed of. First, that the Tennessee General Assembly created the Metropolitan Nashville Airport Authority. It didn't. Metro Nashville is the creating municipality, not the state. It also argues that the state funds the airport, not in any significant manner. The state wisely abandons both of these justifications and pivots to economic development and democratic accountability. For democratic accountability, it talks about having a broader representation by including non-county residents on the board. That was already permissive under the prior version of the act. That isn't a new feature of Section 2 of the act. With regard to economic development, the state introduces a new undefined term of especially significant airport. An airport could be especially significant for a variety of reasons: the number of passengers, the number of flights, the number of airlines that are there, the amount of cargo that it uses. But an airport isn't especially significant because of its form of government. There's not any reason that you would define an airport by the government that it's attached to. This class of one doesn't exist for any rational reason other than to target Nashville. Because irrational classifications cannot be upheld, this is an additional reason how this act is unconstitutional. Finally, I want to turn to the balance of harms. This analysis takes into account the harm to Nashville, the harm to MNAA, the harm to the public, and the complete lack of harm to the state.
Can you address for us the timing issue? The airport authority in particular spent a lot of time in their filings talking about now that the new board has been seated to grant the injunction and undo that would be very disruptive versus if we'd had the opportunity to review this issue before the new board was seated.
Sure. I'll start with the disruption that would occur. The state-appointed board has held 2 meetings successfully. The Metro-appointed board has held 53 years of successful meetings and have led the airport to new heights. With regard to the timing, it's important to look at the FAA's 2016 policy. That policy clarifies the FAA's legal authority and policy for addressing disputed changes of sponsorship. That's exactly what we have here, a disputed change of ownership and governance of the Metropolitan Nashville Airport Authority. The FAA first raised these concerns on March 31st of this year, and it asked that the General Assembly coordinate with them. The General Assembly declined that invitation.
Well, they don't have to, do they?
They do not, but again, the FAA policy does instruct both the airport and the local government and the state governments to coordinate with them to avoid this exact situation.
Well, the letter on that date was actually written to the CEO of the airport authority. I see that it was copied to Governor Lee and to Director Dietz, but I mean, it was a communication with the authority particularly.
Correct, Your Honor, and I apologize if I misspoke.
Oh.
Thank you. So they send that letter. From there, the CEO of MNAA issues his own letter that says, we disagree with the FAA's interpretation of its own policy. Once the bill passes, Metro Nashville has every reasonable expectation that the status quo is going to be maintained, that the FAA's 2016 policy is going to be adhered to. And that's not just because it's the word of a federal regulator, it's because that's what history tells us is going to happen.
Does a federal regulator have the authority to enjoin a state law?
I would not describe what the FAA is doing as enjoining a state law.
Then if that state law is not enjoined, doesn't that mean there is a new board effective July 1st, whether the FAA likes it or not?
So previously, airports have actually worked with the FAA to come to an agreement that the status quo will be maintained. In both Charlotte and Jackson, the boards worked with the FAA, understood the policy, and didn't want to risk their federal funds, so they agreed to maintain the status quo. And they did that with lawsuits pending.
Where is the threat that the airport's going to lose its funding? I know that's Metro's position, but that seems to be contrary to the proof provided by the intervener.
So the proof from Metro Nashville is in the declaration of Kirk Schaefer. Kirk Schaefer is a former deputy administrator of the federal administration. He served under both George W. Bush and Donald Trump. In his experience, at no point has the FAA dispersed grant funds to a board or to an entity whose legitimacy was being challenged.
That seems to be respectfully his opinion, and that seems to fly in contrast to what the MNAA has actually produced, which shows that that's not realistically in jeopardy. And frankly, the FAA letter says they're looking for a court ruling. Isn't there a ruling on this injunction one way or the other going to resolve that issue?
It is one way or the other going to resolve that issue.
So even if we did not grant the injunction and the new board, well, the new board is in place, but if we recognize the new board by not enjoining the statute, doesn't that resolve the entire issue? Because there's no dispute, you'd have a court ruling. It may not be a final ruling.
We would have a temporary court ruling, and initially, and previous cases, the court has waited for the litigation to conclude, the FAA has waited for the litigation to conclude before making a final determination on sponsorship. And again, the MNAA, I want to be clear, they're offering their perspective about, I think the mic went out. They're offering.
I don't think you did that.
I was like, you didn't want to hear that argument. But the MNAA is offering their perspective on what the FAA is going to do. Noticeably absent from the record is any formal assurance from the FAA that it will absolutely disperse grant funds.
I don't think we're looking at a directive from the FAA in the letter produced by Metro Nashville either, though, are we?
You are not looking at a directive, but you are looking at a firm statement that the board that's recognized is the Metro appointed board. I also want to draw this court's attention to a constitutional harm is standing alone irreparable harm. The funding issue with relationship to MNAA is a consequence of the actions that have occurred. And it plays into, Your Honor, I don't know that I ever finished the timeline question that you asked, but it wasn't until June 26th when the FAA issued its letter, because Metro Nashville wanted to dot its I's, cross its T's, and make sure that the FAA policy applied here. So it asked the FAA. And it took the FAA at its word when it said, yes, our policy applies here. From there,
If Metro Nashville knew that you all were under the belief that it applied the entire time, that's why we've got documentation from back in March, why not, just to be safe, was a motion for a temporary injunction not included at the time you filed your complaint? Because you sort of asked for that relief in your complaint, but not with a verified complaint. I think that's the point of Chancellor Martin's question, is why did we wait so late when, just to be safe, this could have been filed from the very beginning and we wouldn't be in a situation where a new board would be seated because we would have acted swiftly?
because we did not have a reasonable expectation that the directive or that the word of the FAA would be disregarded. Our expectation was that that policy would apply, that the Metro board would continue to operate, and then this court would have an opportunity to make a ruling. Until the new board was seated, there wasn't any additional harm. It was the constitutional injury, which is sufficient. But as long as the status quo was being maintained, there wasn't the urgent need for an injunction for this extraordinary remedy. But that need exists now. And as soon as we got the letter from MNAA, also on June 26th, within 3 days, we filed our request for a temporary injunction. The point of an injunction is to avoid irreparable harm, not to wait for it. By issuing the temporary injunction, this court can halt the constitutional violations, ensure that M&A's eligibility for federal funds remains intact. Metro Nashville asks that you find that it has a likelihood of success on its 3 constitutional claims. Specifically, that the Nashville Airport Authority Transfer Act violates the local legislation clause by violating the prohibition on Ripper bills, and by being a local act without any local approval. And finally, that it irrationally creates a class of 1.
Counsel, why does your injunction only ask for an injunction as to Section 2? And the reason that I asked that question is if Metro Nashville is ultimately successful under their theory of this is a violation of a home rule amendment or on the equal protection claim, then this entire act, or at least virtually every part of it, would be rendered unconstitutional. So I think what you're asking for is for the old board to be reinstated, but with the significant powers that the state's invested in this new board, including relating to eminent domain, to be vested in the old board, but then ultimately at the end of this lawsuit removed as well. That seems odd to me.
The immediate harm flowed from the displacement of the Metro appointed board, which is
Isn't there immediate harm if a Metro appointed board that the state legislature did not want to have this power, the state legislature wanted the state appointed board to have this eminent domain power? Isn't there immediate harm if the old appointed board exercises a power the state legislature did not want them to have, just because of how your injunction's structured?
There could be, Your Honor, and we wouldn't object if this court wanted to go further than what Metro Nashville requested.
But that's not the relief you requested, and that didn't give the state an opportunity to respond as to the other sections. Actually, they specifically wrote in their response that they weren't responding to those other sections because you didn't raise them.
We didn't, Your Honor. Again, Section 2 is regulating the conduct of Metro Nashville, and that's the provision that we chose to focus on.
Section 6 would give the Nashville Airport Authority authority for eminent domain proceedings. That is as significant as anything in this legislation, isn't it?
It is very significant, Your Honor.
How did that happen before this act went into effect if there needed to be an eminent domain proceeding for the airport to acquire more property?
The airport would work with the metropolitan government to exercise those power, is my understanding.
So this would transfer, if we grant relief in the form that you've requested, it would transfer that power from metro government to the airport authority, at least temporarily.
It would, Your Honor, but that's less concerning when the airport authority, which again is a tentacle of Metro Nashville, is being governed by individuals appointed by Metro Nashville.
Well, not if the state didn't want a locally appointed board to have that power.
And that's where the severability clause comes into effect, because it was intended to apply to sections 3 through 9, which meant that the legislature contemplated that section 2 might be severed away and sections 3 through 9 still in place with a metro appointed board.
But if we agree with Metro Nashville about home rule, then section 2 is gone, so are the rest of those sections, because they still have that same requirement of population of 500,000 people in a metro form of government.
Right. They seem to be, they're specifically crafted to apply to this new board. And if the new board concept goes away, then the other changes seem unnecessary.
Would also go away. I would agree with that, Your Honor.
I think the only way that ends up being the ultimate result is if this court agrees with the Ripper Bill theory, but not the home rule or the equal protection theory.
That's one way.
That's the only way that outcome that you're requesting in a temporary basis becomes permanent. If I didn't make sense, I'm sorry.
If you could repeat yourself, Your Honor, I apologize. I was trying to follow.
I'll do my best. What you're proposing as a result of this temporary injunction is that the section 2 goes away. The rest of the sections are in place, which gives that power to the old board. The only way that ends up being the permanent result is if this court agrees that this is a Ripper Bill as to section 2, but we don't agree about home rule or equal protection.
Your Honor, as you noted, we did challenge the entire act in our initial complaint. And so the permanent result could be that the entire act goes away through the process of this litigation.
Which is my point. So I don't understand why the action wants the old board to temporarily have these expansive powers if the whole thing is going to be unconstitutional at the end anyways.
I think that is a fair point, Your Honor. Again, we did just, for the court's convenience, try to focus on section 2. If there are no other questions, we would ask that you enjoin the act.
Thank you so much. Now we'll hear from the state.
Good afternoon.
Good afternoon.
Can you hear me okay?
Yes.
Once again, I'm Timothy Simons. We're here for the state defendants, and that's Governor Bill Lee, Lieutenant Governor Randy McNally, and Speaker of the House Cameron Sexton. And before I get into the actual details of the argument, may it please the court, with the permission of the court, we wanted to split up our argument.
That's fine.
So Mr. Shirley is going to address the success on the merits prong, and I'll address the other things. But since Counsel for Metro is really focused on the success on the merits, I'll probably do some introductory remarks and turn it over to Mr. Shirley, and then I'll deal with irreparable harm and those issues on the tail end if the court's okay with that.
Of course.
Thank you. And I'd like to back up a little bit just to talk a little bit about the background of this matter to give the court perspective. I know there's been a lot of submissions dealing with these matters, and I'd like to provide a little condensed version of that that might assist the court in kind of seeing where we are in the logistics of this act and this lawsuit. Now, this statute that we're talking about is Chapter 488 of the 2023 Tennessee Public Acts. And based on the motions and filings of Metro Nashville, they're seeking to enjoin just Section 2, which is the point that was being discussed earlier. And with respect to that motion, the state defendants opposed the motion for temporary injunction, and we respectfully request that the court deny that motion. As far as a little bit about the background, this act, I'm going to refer to it as the act, was passed on April 21st by the General Assembly, and Governor Lee signed it into law on May the 19th. And it makes several changes to the Metropolitan Airport Authority Act, which is found at TCA 42-4-101 to 117. And it governs metropolitan airport authorities, including MNAA, which is the one that's at issue in this case. Now, the airport authority, which was created by resolution in 1970 by the Metro Nashville legislative body, in that resolution, it was acknowledged that this airport authority is its separate body, politic and corporate, and under the act, it's vested with many different authorities, including right to own property, to contract, to basically operate the airport. And in fact, as part of that resolution in 1970, the airport authority entered into a contract with Metro Nashville that governed the transition so that MNAA would be operating the airport and have control of the facilities. So this issue...
But the act does define it as an agency, an instrumentality of the creating authority.
It does, Your Honor.
I understand that's amended under the new legislation.
It does, but obviously the act also talks about that it can sue or be sued, and it's recognized as a separate entity. Now, there were some discussions in the pleadings and the submissions about the motion for temporary injunction on whether this act changes this from some kind of component of the state or component of Metro Nashville. For purposes of this motion, as we pointed out in our plea, that's irrelevant to this because that classification is an accounting classification. It has nothing and doesn't affect in any way the MNAA and its ability to operate as a separate entity and to operate the airport. So we think that's not really an issue of consequence in ruling on this motion for temporary injunction. But basically, the three claims that in the amended complaint, they've challenged the act, and it's the local legislation clause in Article 11, Section 9, they claim the act violates that it's also known as a Ripper bill, and in violation of Article 11, Section 9, and also they assert an equal protection claim under Article 11, Section 8. So what I would like to do to address the merits of those things, I'll turn it over to Mr. Shirley, and then I'll wrap up at the end.
Okay,
thank you very much.
Mr. Shirley, we'll be pleased to hear from you.
Good afternoon.
Good afternoon.
Can you hear me okay, or do I need to raise this up? Okay. All right, I'm Jonathan Shirley, Assistant Attorney General. I'll be addressing the success on the merits prong of the temporary injunction analysis. As Mr. Simon said, Metro makes three claims that the act violates the Tennessee Constitution. First, that it violates Article 11, Section 9 because it's a Ripper bill. It violates Article Section 9 because it fails to require local approval. And it violates Article 11, Section 8, the equal protection guarantee in that section. So I'll address each claim in turn. First, the act is not a Ripper bill. The Home Rule Amendment prohibits the General Assembly from passing a special local or private act having the effect of removing a municipal or county office holder from office. Here, Metro's argument fails for two reasons. First, airport authority commissioners are not Metro officers. Accordingly, Metro does not have standing to raise this claim. And second, the act is not a special local or private act. I'll first talk about why airport authority commissioners are not Metro officers. I think Metro Nashville fails to give adequate regard to two separate Court of Appeals decisions from 2004 and 2007 that emphasize the separateness of the airport authority and the creating municipality. In the 2007 case, Metro Nashville versus the Employee Benefit Board, the court considered whether park rangers qualified for a rebuttable presumption of causation under the statute at issue. In resolving that dispute, the court distinguished an earlier case in which it held that the airport authority was a separate political subdivision of the state of Tennessee. It was an entity independent of Metro Nashville. Accordingly, airport authority employees were not Metro Nashville employees. Additionally, in the City of Memphis v. Civil Service Commission of the City of Memphis case, the court, after considering the many distinct corporate powers and duties of airport authorities, and notwithstanding the fact that the city appointed the airport authority commissioners, determined that the airport authority constituted a separate and distinct entity, and its actions could not therefore be imputed to the City of Memphis.
How does that contrast with the fairly clear language in Section 42.4.102A, which seems to describe the board specifically as a public and governmental body, which is an agent and instrumentality of the local government?
And we certainly don't deny that they're public officers, a public body, and I think they could still be an agency or instrumentality of Metro, but
they
not
have
be
to
county
be local,
officers.
right? They have to be local.
They do, and I'd like to direct the court's attention, if I could, to the 1984 AG opinion that we included in the notice of filing yesterday.
And I will confess I have not read anything that was filed yesterday. I didn't know that till it was mentioned moments ago.
So in that opinion, the AG considered whether the Memphis Shelby County Airport Authority and its officers were, quote, officials or offices of county government. The AG lists many of the same powers of airport authorities we discussed in our brief and says, with such distinct corporate standing and powers, the Memphis Shelby County Airport Authority is thus not a mere office of the county government, although as a public and governmental body, it acts as an agency and instrumentality. So the AG there is acknowledging that it could be an agency or instrumentality, but that doesn't make it a county office. And I'd also like to point the court's attention to the Foster Wheeler Energy Corporation versus Metro Knox case. This is out of the Sixth Circuit, and it's also in the notice of filing that we provided to the court yesterday. In this opinion, the court considered whether a creating municipality in the county could be liable for the contracts entered into by a corporate entity they had created. The Sixth Circuit held that although some Tennessee cases affirm the proposition that subsidiary corporations of a municipality may be an agent of the municipality for some purposes, one cannot conclude that a city is thereby liable for the contractual obligations of the corporation. So there's authority out there that emphasizes the separateness of the authority from the creating municipality, and we think that you reach the natural conclusion that the commissioners are not Metro officers. So the airport authority commissioners are approving the contracts that Metro is not liable for. They're making decisions that can bring liability upon the airport authority. Metro is not, that liability is not imputed to Metro.
Do we have any authority that shows that contractual liability and things of that nature are factors that need to be considered in determining whether someone's local for purposes of the Home Rule Amendment regarding the anti-RIPR bills?
Not for purposes of the Home Rule Amendment. I think that the Foster Wheeler case I just cited, it just talks about how they're separate, and you can, that they make the conclusion that even though there's an agency or instrumentality for some purposes, they are not
Might
liable
some
in
of
the
those
contracts.
purposes be the anti-RIPR bill or the anti-RIPR provision?
Sure, Your Honor, and I think that I'd like to talk about the comparisons made to the boards of education, the Metro made in its brief, because I think this is helpful. So in its reply, Metro compares airport authorities to boards of education and cites the case law holding that county boards of education are qualified as county officers. But school board members are different than airport authority commissioners. They're elected, they have direct involvement in considering and approving county and municipal education budgets. But notwithstanding that, the Supreme Court held in the Metro versus Tennessee Department of Education case that, quote, while county boards of education operate in a sense as county government entities, the county boards of education themselves are not bestowed with home rule authority. And that's at page 154 of that decision.
Was that an anti-RIPR or just a home rule?
That was a home rule.
I mean,
bill,
is the
but
state
not-
taking the position that the state legislature can pass a bill that vacates the Campbell County Board of Education, where I'm from, for example?
I don't think we would take that position. I mean, our position here is that it's also a law of general applicability. So that the RIPR bill provision wouldn't come into play. And back on that education case, accordingly, local education agencies could not logically be deemed to be endowed with the protection of the Home Rule Amendment. The court ruled that the ESA Act was not applicable to Metro Nashville. Instead, it applied only to LEAs. In other words, the county boards of education were separate and distinct from their affiliated local governments, and the act applied to one but not the other. The same way the act here applies to the airport authority and its officers, but not Metro Nashville.
Isn't that really more about local informative effect, not whether or not those are local officials? Surely a school board member is a local official for purposes of the anti-RIPER bill.
Right, but we would argue that they're not Metro Nashville local officials.
Which means that the state, under that position, the state could disband the Metro Nashville School Board if they wanted to.
I don't think that the state could disband the Metro Nashville School Board.
Because a school board member is a local public official.
That's a fair point, Your Honor.
Let me interrupt you
Go
for
ahead.
just a second. Are you telling us all of this about the office holders of the airport authority for the purposes of standing? I mean, these are office holders in the airport authority, which is, by black letter law, an agency and instrumentality of Metro. You say they're not employees of Metro. Is that for standing purposes? But these are office holders who are being stripped of office. No question about it. They're being replaced, right?
That's correct.
So we're talking about standing, or are you trying to argue that it's not dispossessing office holders before their term's in?
We're not arguing that. I think it does come into play for standing. As Mr. Simon said,
Standing.
The airport authority has the authority to sue and be sued under the Metropolitan Airport Authority Act.
I understand it's a separate organization. Independent body politic, I think, is one of the phrases in the originating act of the thing. But what about this idea that Metro, for standing purposes, what about this idea that Metro is asserting its own rights to populate the board, and Metro is not asserting its own rights with respect to the officers of the airport authority? What about that?
I think that if the court, well, I think the appropriate person to allege that they're being removed from office would be the officer themselves.
No, that's not what I said, and that's not what she said. What she said was Metro asserts its own rights to populate the board. That is to, she didn't say populate, that's my word, to make the appointments, to remove office holders who the Metro board deems unfit. I don't know that that's happened, but they have that authority, and they've lost that authority. Why don't they have standing to assert that injury in this lawsuit?
Your Honor, I think our position is just that to that extent they may have standing, but to the extent that the officers are being removed from office, that would be the airport authority or the officers' prerogative to bring that lawsuit. They can sue and be sued. They can assert their own rights.
So you're saying they are local officials, but for anti-RIPER purposes, but the metropolitan government doesn't have.
They're not Metro Nashville officials for anti-RIPER purposes.
I
think that's our position.
Are they? And I need to look at the language of the statute or of the constitutional amendment to properly ask this question. If you'll.
Here it is.
Let me find it. I got it. No, I was wrong. Yeah, I've got it. It's an incumbent of any municipal or county office. So you're arguing they're not Metro officers. If one of those affected board members intervened as a plaintiff in this suit, do they have standing to say that they are a municipal or county officer? Or are you saying they're just not municipal or county officers at all?
I don't think we're saying they're not a municipal or county officer. I think they would have a
So
better
this is an
argument that they have
anti-RIPER
standing.
bill. Metro Nashville just doesn't have standing.
Right.
So this is an unconstitutional bill as to Section 2. Metro Nashville just doesn't have standing to assert it. That's the state's position.
No, we do not agree that it's unconstitutional.
Well,
I mean-
if it's removing a municipal or county office holder, public office holder, it's an anti-RIPER bill. So if they are those office holders and they have been removed, then it's just standing as to that.
Well, it is standing to that, but there's another reason it's not a RIPER bill, and that's that it's generally applicable.
Who
local.
else was removed from office other than the Metro Nashville board members?
No one has been yet, but the act is applicable to future metropolitan governments. So if I could, I'd like to talk a little bit about the general applicability. As the Supreme Court said in Ferris v. Blanton, an act is not local if it's potentially applicable throughout the state. In Ferris, the Supreme Court invalidated an election law that applied to every county headed by a mayor. The court observed that Shelby County was the only county affected by the statute when it was passed, and importantly, that no other county could potentially have the type of government that Shelby County had without some further affirmative act of the legislature. And as the court says in the Burson case, Ferris has been distinguished several times on the grounds that the enabling provisions for the creation of metropolitan government were extant and potentially available to all counties statewide. The Burson court cites specifically to Doyle v. Metro Nashville, where the court upheld a law that applied to counties having a metropolitan form of government, even though Davidson County was at the time the only county affected by the act. And the court cites to Bozeman v. Barker, where a statute was upheld where its terms only applied to 2 counties based on population and could apply to others as populations grew. So in Burson, even though the statute at issue required only 1 county to take affirmative steps to comply, the court emphasized that other counties were certainly affected because they had to maintain compliance. And importantly, that other counties would eventually come within the purview of the statute as populations increased.
How do they come within the purview of the statute in Burson? Because I think we're getting into something important.
In Burson, I think as populations increase, they would come within the purview
It says
of the statute.
simply population of 300,000.
Mhm.
It also means that someone could populate out of it if there was a decrease in population.
Presumably.
That seems to be distinct from the statute here, which states that it involves a county having a metropolitan form of government with a population of more than 500,000 according to the 2020 federal census. The statute in Burson makes no mention of a census or a subsequent federal census, which precludes any county from becoming part of this until the results of the 2030 census. So no one can grow into this statute until 2031. That seems to be different from Burson.
Well, I think arguably Memphis, Shelby County already meets that population threshold.
They do. Isn't that why that we had a population threshold wasn't good enough for the statute? They had to include the metropolitan form of government stipulation as well to ensure that Memphis was precluded from this act as well? That was its purpose, wasn't it?
No, our position is that well, let me back up a little bit. Number one, I think the reason, it's clear that they intended that future metropolitan governments could grow to come within the purview of the statute because they included that subsequent federal census. Clearly, Metro Nashville falls under the 2021, so they're not going to qualify under the subsequent.
Also, they can't populate out of it, right? And who knows, we've had major global events that have drastically changed the sizes of various American cities over the last couple of years. If something happened that caused Nashville to have a sudden decrease in population, they can't populate out of it either. That's another distinction between that and the statute discussed in Burson.
The way that the way the act is written, Metro Nashville would always qualify because as of the 2020 census, they have a population above 500,000. But we think it's important that the legislature, it's important to note that the legislature included that or subsequent federal census language in there because that shows their intent that another metropolitan government could come within the purview of the statute eventually.
But they absolutely can't within the next 9 years unless Shelby County consolidates.
That is correct. So let me talk a little bit about Section 2(1)(c) of the Act, which is the staggered term section that Metro raises issue with. Metro argues that the tight time frame makes clear that the Act is only designed to apply to Metro Nashville. We don't think this is the case. As the court notes in the Board of Education of Shelby County case, potential applicability turns on the substance of the statute, and the operation or application of a statute's classifications or conditions speaks to its potential applicability. And then at page 652, the court cites to the Doyle case and says that the Doyle court found that the statute's condition that any city having a metropolitan form of government was general because it applied to all those who desire to come within its purview. And so it's important to distinguish from the Ferris case where the form of government had by Shelby County, it would require an affirmative act of the legislature for another county to be able to come within the purview of that statute. Here, the metropolitan government enabling legislation is available to anyone that wants to come within its purview. No further act of the legislature is necessary, and so we think that that's important to distinguish. And then additionally, in that Board of Education of Shelby County case, the court notes that what made the application of the statute at issue in Ferris merely possible or theoretical was that the General Assembly would have been required to pass a separate act to include additional counties. And although the General Assembly might have acted, the court dismissed that possibility as hypothetical. And so we think Section 21C could absolutely apply to Memphis if it were to consolidate in the next few years. As the cases we cited hold, the enabling provisions for the creation of metropolitan governments are available. We think this alone is sufficient to make it more than merely possible or theoretical that other governments can consolidate. And indeed, as Metro points out, Memphis-Shelby County has tried to do that several times in the past. It's not unreasonable to think that they might not do that again.
Do we know that the timing of both the consolidation, the timing of Section C, and the timing of Memphis's current board members would cause this statute to force those board members to vacate their terms?
Repeat that one more time for me, please.
If we consider the timing of Memphis's board members' terms, the timing it would take to consolidate, and the timing prescribed in Section 2, subsection C, would that force a vacation of those board members' terms?
I think it would depend on when they're able to consolidate.
So we don't know.
We don't know the answer to that. So citing to that same case, Metro Nashville also argues that the fact that there are multiple conditions confirms it's only theoretical at best that the act could apply anywhere other than Metro. But in that case, there were several separate conditions that were trying to apply to 8 counties. Here, there are only 2 conditions, population and metropolitan form of government. Memphis has already met one of those. Knox County is close.
And a third one, it has to have an
airport authority.
And a population of at least 100,000, because you have to have that to have an airport authority.
So your
Create
theory
airport
is that
authority.
Memphis would take the affirmative steps to consolidate its government to make sure that it got the authority to appoint its airport authority taken away and come under the statute?
If they wanted,
That that's going to happen?
if they wanted, we think if they wanted to come within the purview of the statute, they could, and that's enough to make it not. That's enough to make it more than theoretical. Or merely
Wouldn't the
possible.
statute effectively ensure that Shelby County never does that? Because with all due respect to what's been referred to as the flagship status of BNA, there's probably not an airport in the United States that has as much of a commercial impact on our economy as the Memphis airport because of FedEx.
That's a good point, Your Honor. And
I mean, that airport is, every airport's important to its community. That airport is incredibly important to its community, and there's no way that they're going to do something that messes with what they have going there.
right. Our position is. Were you going to ask a question? Okay. Our position is that the fact that the enabling provisions for metropolitan government are extant and potentially available to anyone that wants to come within the purview, that's more than enough to make it more than theoretical or merely possible for someone to come within the purview of the statute.
But until the 2030 census results, that is only Memphis and only if it takes the affirmative steps to become a consolidated government.
That's correct. And so let me talk a little bit about severability, because we believe 21C is generally applicable, but if the court disagrees with that, it could sever that portion of the section and leave the main thrust of the law intact. So in its reply brief, Metro argues that the court need not address severability because only Section 2 of the Act is being challenged. But the court may, under appropriate circumstances, sever an unconstitutional portion of a statute and find the remaining provisions to be constitutional and effective. And that's from the Lowe's Company's case that was in our notice of filing. So Tennessee law permits severance when it's made to appear from the face of the statute the legislature would have enacted it with the objectionable features omitted. Severance would be appropriate here. By including a severability clause in Section 10 of the Act, the General Assembly made clear its intention to keep the remainder of the Act in force if any portion of the Act were to be declared unconstitutional. It's not limited to Sections 3 through 9. It says any portion of the Act. And that's supported by the Gibson County School District case that's in our notice of filing. Additionally, Tennessee Code 13110, which is the general severability statute, it allows sections, clauses, sentences, and parts of the code to be severable. So severance of this one subsection would not render the Act inoperable. Airport authorities and metropolitan governments would still gain the same powers that the Act provides for The governor, the speakers, the mayors would still make appointments. There's section 21C, and then you would also have to do the first clause of 21D that refers to 21C. If those were severed from the act, we'd simply be left with 4-year terms for all members, beginning on July 1st of a given year and ending 4 years thereafter. So if I could, I'd like to move on to the second point. The act does not require local approval. For an act to require local approval under the Home Rule Amendment, it must be local in form or effect, it must be applicable to a particular county or municipality, and it must be applicable to that municipality or county in its governmental or proprietary capacity. Here, the act is not local in form or effect, as we just discussed in the Riverville context, but we'd also take the position that it's not applicable to Metro Nashville. The act applies to metropolitan airport authorities, not metro governments. And as the court held in Metro Government of Nashville versus the Tennessee Department of Education, an act applies to a municipality or county if it regulates or governs the county or municipality. And whether a particular act affects a county or municipality must not be conflated with whether it's applicable to a county.
What about the fact that Section 108, which is the eminent domain section, which Judge Weldon was asking you about, it provides currently that the creating municipality would essentially acquire the land and then would cede it somehow to the airport authority. The change in this statute allows the authority to go do that for itself.
That's correct, Your Honor.
So don't you think that that has an impact on Metro as the creating municipality?
Well, I think we would argue that it might affect them, but I think the purpose of
The
that...
ability to go condemn land by eminent domain?
For the airport authority. They're doing it on behalf of the airport authority.
Which no longer is controlled by the local government.
Right, because the new act gives the authority to the airport to do that itself. Our position is the act regulates and governs airport authorities. We think this is evident from the plain language of the act as a whole. Section 2 specifically sets forth the various requirements for the makeup of a board of commissioners of the airport authority, including the number of commissioners, qualifications, background, length of term, and conditions for removal, and reporting and auditing requirements. And the act as a whole is applicable to airport authorities because it grants them significantly more power to carry out the purposes for which they were created. And so because it's not local in form or effect, because it's not applicable to Metro, it does not require local approval. Third and finally, the act does not violate the Equal Protection Clause of Article 11, Section 8. We believe Metro's equal protection claim fails here for 2 reasons. First, Metro does not have standing to raise an equal protection claim in this instance. And second, even if they did, the act is supported by a rational basis. The Tennessee Supreme Court has held on numerous occasions that Article 11, Section 8 of the Tennessee Constitution confers the same protections as the 14th Amendment. And in considering an equal protection challenge to a legislative act, Tennessee courts follow the analytical framework established by the U.S. Supreme Court. In our brief, we've cited many federal cases that hold the political subdivision of the state does not have the same rights as private persons.
Well, that's under the 14th Amendment. Isn't there some pretty clear state court authority that cities or municipalities can raise equal protection claims, and it's a rational basis analysis? I recognize the U.S. Supreme Court hasn't held that under the 14th Amendment, but this was challenged under the Tennessee Constitution. That's
correct, and we think there are several Tennessee Supreme Court decisions that support that position. For example, in the Smitty v. City of Memphis case, which is one that we included in our notice of filing, the court held the municipality has a dual existence, has the rights of an individual, and as such, in the exercise of those rights, may enjoy the privilege and immunities, and must bear equal burden with other citizens. In such capacity, it is under the protection of Article 11, Section 8. However, the court goes on to say that in its capacity as an arm or branch of the state government, and in the exercise of its governmental functions, the city is to be treated as a political subdivision of the state. And its governing or political rights are all to be regulated by those provisions of the Constitution which refer to it in that capacity. As Metro admits in its memorandum, Metro acted in a governmental capacity when appointing board members. State Ex Rel. Bell holds similarly. The court holds that between the state and municipal corporations, such as cities, counties, and towns, the relation is different from that between the state and the individual. Municipal corporations are mere instrumentalities of the state for the convenient administration of government, and their powers may be qualified, enlarged, or withdrawn at the pleasure of the legislature. And then in Bozeman v. Barker, which is a case we cited in our brief in the home rule context. But the court held specifically regarding Article 11, Section 8 in that case, that the questioned act affected the counties subject to it in their governmental or political capacities or agencies. Thus, the provisions of Article 11, Section 8 were not contravened by the act in question. And then, as you know, we've also cited the Metro Development Housing Authority case, which is a contracts clause action, but it holds that a county, as a mere arm of the sovereign power, can have, as against the legislative power of the sovereign, no vested rights in the powers conferred on it for governmental purposes. And so it would be our position that these cases support the idea that Metro would not have, because it's acting in its governmental capacity, this is a general law, they don't have standing to pursue an equal protection claim in this instance. Even if the court disagrees and finds that Metro does have standing to bring an equal protection claim, we would submit that the act is supported by a rational basis. It's undisputed that rational basis applies here. There's not a target or suspect class, and there's no fundamental right that's being infringed. Rational basis is an extremely deferential standard. All that's required is the act must be rationally related to a legitimate state interest. The court must uphold the statute if any state of facts can reasonably be conceived to justify the classification, or if the reasonableness of the class is fairly debatable. Metro
So what is the rational basis for this?
We think there's two legitimate state interests. First, the act was intended in part to recognize the flagship status of BNA and to ensure the continued success.
So the act was intended to specifically affect Nashville.
Ensure the continued success, growth, and development of that kind of airport, an airport like BNA. At the same time, the legislature expressed a desire to ensure that such airports were accountable to more than the residents of a single county. These interests are reflected in the act. For example, the act grants any affected airport authority the power to use eminent domain directly, rather than relying on another entity. The act also expands an affected authority's control over aircraft hazards and other land use issues.
How am I supposed to comport the issue of the involvement of people in surrounding counties? For one thing, that's true for every airport in the state. You know, we only have 5 true passenger airports in the state of Tennessee. Anybody that lives in a rural county or a suburban county has to, I mean, there's not an airport anywhere near me except Knoxville, which actually isn't in Knoxville, it's in Blount County. So we're saying that our rational basis is the significant impact that an airport like BNA may have on its surrounding counties and those citizens' vested interest. If you look at the Knoxville airport, which is precluded from being regulated by this act, the Blount County residents are the ones that actually have to deal with air traffic noise and obstacles and barriers and eminent domain, but we're more concerned about a regional impact in Nashville, but not in Knoxville, where the airport isn't even in Knox County.
It's a good question, Your Honor, and I'll talk about how the act is rationally related to those interests, and it relates the population classification and the metro government status. We think both of those are reasonable proxies for these problems.
How does a population for one county translate to the involvement of citizens in the surrounding counties? What does that have to do with anything?
Okay, so if there's some fit between population and the legislative interest, we think that's sufficient. So in the Taylor v. Armentrout case that we cited in our brief, the Tennessee Supreme Court upheld a statute that classified local governments based on population, because governments in the higher population brackets were more likely to attract travelers, business people, tourists, and others. In the context of the airport, the volume of travelers, whether for business, pleasure, personal reasons, is especially relevant to the scale of the social and economic effect of the airport. Therefore, we think it's reasonable to restrict the effect of a statute to only those airports likely to have an especially high travel volume. So that relates to the population classification.
Why didn't it just relate to the passenger volume or flight volume of a particular airport then, instead of using a proxy?
Because the higher population areas are more likely to have that kind of stuff that I just mentioned.
But you're saying it's a proxy for increased air travel. Why wasn't it just related to the amount of air travel?
I would just say that I think the legislature has used population classifications frequently in the past, and those have been upheld. I think that's supported by I think it's the Hart case that we cited, and that lists out several cases in there where the legislature has used a population classification. So it's a
and to be fair, they did that to create the airport authorities in the first place. Only counties with 100,000 residents can even have one.
Right. And so, like I said, we think it's reasonable to restrict the effect of a statute to those airports likely to have an especially high travel volume. There's also a rational basis, we think, for the Act's form of government classification. The enabling legislation for the establishment of metro governments makes this clear. Metro governments are formed to fulfill the unique and urgent needs of a metropolitan area, a modern metropolitan area. That's from 71102 of the Tennessee Code. So both the purpose of a metropolitan government and its structure directly implicate the development promoting interest and its resultant expansion of the authority of these types of airports.
So because a metropolitan government is so good at development, they need to not have authority to appoint their airport board? Is that the rational basis I'm supposed to draw?
We think the rational basis you're supposed to draw is, since the purpose of a metropolitan government is precisely to enable a more efficient response to the complex problems of a modern city, the legislature could reasonably use a local government's choice to adopt a metropolitan form of government as a proxy for unique issues likely to raise significant problems for future development. And I'd like to close by just noting a couple things. Plaintiffs rely on selective portions of the legislative history of the Act to argue that Metro Nashville was allegedly the target of the legislation. Reasons for the Act are pretextual. But our position is that these snippets of legislative history cannot prove plaintiffs' claims. Tennessee courts have specifically addressed the appropriateness of relying on statements of specific legislators in the context of a constitutional challenge. In American Show Bar series, which is cited in our notice of filing, the court refused to consider statements from individual legislators, noting that what motivates one legislator to make a speech about a statute is not necessarily what motivates scores of others to enact it. And the stakes are sufficiently high for us to eschew guesswork. Accordingly, the court held that the statements were irrelevant and had no bearing on its analysis of the constitutionality of the Act.
What about when it's the sponsor of the legislation that made it pretty clear this legislation explicitly targeted Metro Nashville?
I would say it's still the statement of one legislature, and that doesn't legislator, and that doesn't necessarily mean doesn't necessarily mean that's the reason that other legislators voted for the Act. And then
it's the reason he talked in great detail about how he crafted the Act, though.
That is true, but we think that, as the court said in the DirecTV case versus DirecTV Inc. versus Roberts, warned that legislative records are not always distinguished for their candor and accuracy. Rather than reflecting the issues actually debated by the legislature, legislative history frequently consists of self-serving statements favorable to particular interest groups. The legislative statements of one member or group of members can also cannot be reliably attributed to all members. Some even question whether a single motive can ever be attributed to legislation. Here, plaintiffs quote these self-serving statements of a small number of legislators to impute alleged motivations for passage of the Act to the entire body. And we think the court should not look beyond the language of the Act itself, since the language of the Act is clear and unambiguous. Consequently, the statements cited by plaintiffs have no bearing on the constitutionality of the Act and should not be considered by the court. For these reasons, we believe plaintiff does not have a likelihood of success on the merits. I'll turn it back over to Mr. Simons for the irreparable harm.
I would like to focus back on the actual motion that's before the court. The court asked a couple of questions of Metro Nashville dealing with this, the position we took in our plea submissions about unreasonable delay, which we cited the court. The law is clear on this. This is an extraordinary remedy, injunction. And the parties are required by the law to act with reasonable promptness, and that's the language that's used in the court decisions. And if you look at the fact pattern that exists in this case, I think it's from the record, the undisputed record, that there was an unreasonable delay in the amount of time before Metro Nashville sought this. This was a a law that, with regard to taking effect, it was passed on April 21st, signed into law on May 19th. And I think from the record, it's established that Metro Nashville was well aware of this as it was being debated in the legislature. And there was testimony for and against this legislation. So it did not come as a surprise when Governor Lee signed this on May the 19th that with this July 1st deadline, that this was a reality, that if they felt like that there was a need to take action to secure a temporary injunction, then that action should have been taken immediately after the law was signed. And as we pointed out in our brief, we've had another case where there was a similar lawsuit with regard to the Metro Council case, and we cited the factual circumstances there where Metro Nashville filed a few days after it became into effect, and we had an expedited briefing schedule, and there was a court decision that was rendered addressing the motion for temporary injunction before the May 1st date in the act. And in this situation, there were certain deadlines that had to be met by Metro Nashville. So in this situation, with that fact pattern, very similar to this one, we're sitting here today with a hearing on the merits of the temporary injunction 28 days from when it was filed. So our position on that is reasonable promptness would require Metro Nashville, in order to bring this before the court, is to have filed this way earlier than what they did. And what's the result of that? Well, the result is they filed the motion for temporary injunction on the eve that, a few hours before July 1st. This became, by operation of law, the new board, came into fruition. The appointments had happened prior to July 1. That was not a surprise either. There were announcements made of these new appointees. And so the situation arose where they went on pursuant to the law. It's a presumptively valid statute. They went on about their business and started conducting operations, running the airport. They've had 2 meetings. They've appointed committees. They're moving forward. And because of that, the fact that they have filed a motion for temporary injunction to say, hey, wait a minute, we want you to unwind all that. Now, when we could have done it a long time ago, flies in the face of this whole legal principle about the reasonable promptness.
Let me ask you this, Mr. Simons. If the court were to agree with you and that the unwinding and the nature of the relief sought and so forth, how quickly could this case be ready to be heard dispositively? I mean, is this one of those situations where it just needs to be teed up for summary judgment? Or is there any discovery necessary?
Your Honor, and we've been consistent on this approach. We think under Rule 57, a speedy hearing, because these are deck action claims, we have no problem with an expedited briefing schedule and moving forward with summary judgment, and we've made that point clear. So the issue, and I think that point also dovetails into the issue about irreparable harm, which is, I don't think we're looking at a situation in litigation that's going to go on at the trial level for years. We're looking at a situation where we're going to have potentially, and we would be open to this, an expedited scheduling order to get this teed up for summary judgment, to have a ruling on the merits. And in that situation, Your Honor, we think that's the appropriate remedy in this case, is to go ahead and pursue that under Rule 57, but not to upend the existing status quo, which is we have the new board that's conducting business, and contrary to what Metro is claiming, the lights are still on, the airplanes are still landing and taking off, and business is still being conducted over there. So, this fallacy that somehow the world's coming to an end for the next few weeks while we litigate this matter and get it to summary judgment is just a fallacy. The other point I would mention about all of this, Your Honor, is this issue of irreparable harm, which is a key element on the motion for temporary injunction. You have to show irreparable harm. Now, initially, they focused on this whole concept of, well, it's all this harm that's going to happen to the airport authority. Now, they've kind of pivoted away from that and say, no, well, it's also our harm too. But if you look at the situation with regard to what's happening, and look at the submissions from the Airport Authority itself. They take issue with all the allegations, as we do, that there's some kind of irreparable harm that's happening as far as funding or incurring of debt. And we go into a lot of detail in our brief showing how the arguments that Metro Nashville throw out to say there's chaos, there's financial chaos, there's all kinds of things that's going to hinder the Airport Authority's business operations are not true.
Well, it's been like 5 minutes. I mean, to be fair, it's not, I mean, we don't really know how this is all going to play out. There's clearly some tension here among the parties about different issues and control, and the FAA isn't being, I'm not sure how consistent the FAA is being in its communications with everyone. We are trying to read between the lines a little bit. But you are right. It is, the lights are still on. Business is being conducted.
Well, I heard the airplanes all night from my hotel.
Well, and let me make one more point to that,
Yeah.
Your Honor, and that is, if you look at the situation, when they were trying to fashion this argument about irreparable harm, they kept referring, well, this is now a component unit of the state, and therefore they're going to have to get all the budgets approved, and they can't spend any money, or they can incur any debt. And we went to excruciating detail in our brief to show that's just not true. That they operate on their own, they generate their own income. There's even
Which
if
also cuts against the state's argument that somehow, the airport is being propped up by state funding, which was one of the things that was argued in the legislature.
I don't think we took that position.
No, you did not.
But as far as the situation that goes with regard, even if assuming that this was a component unit of the state, it switched, there's been an appropriation that's passed. All those arguments fall apart. This is not a situation where they're in financial jeopardy because of the situation of where we are now with the board being reconstituted and conducting the affairs of the airport. So obviously, in that situation with regard to the irreparable harm prong, it fails as well there. And we would point to the Airport Authority's own submissions on that, discussing the current situation. And if you look at the balancing of the harm, we think what you would effectively be doing if you granted an injunction, you would be disrupting the status quo and reverting back to putting a board in that's now no longer legally in existence. And I think the harm to the state, and that gets back to what I was talking about, is if you're going to pursue something like this extraordinary remedy, you need to bring it promptly. You need to get it before this court, to give this court an opportunity to decide it before that July 1 target date, which they did not do. So in light of those arguments and our reasons for opposing this motion, we'd ask the court to deny the motion.
How do we need to, in looking at the 4 factors that we have to consider on a temporary injunction, how do we consider the harm of having these ping pong boards? If we were to grant the injunction, we'd have the 3rd board being reconstituted in a matter of weeks. How do we balance that type of harm if this panel does think that the plaintiff is likely to succeed on the merit? Because that's almost determinative, the 3rd factor.
Well, first of all, Your Honor, I don't think you get to that analysis because I don't think they brought this reasonably promptly. And I think you don't get to that analysis if the court finds that they didn't bring it quickly enough.
What if we find it wasn't prompt, but it wasn't unreasonably so, and just considered that in the balance of harms? Well, if you're looking at the balancing and you're trying to fashion some issue, I think it all ties into Rule 57, Your Honor, because we don't think the injunction should be granted, and I think if you're concerned about these competing boards, the best way to deal with that is not to upend the current board, which is now running the airport, but is to move forward with a expedited litigation schedule with summary judgment motions and moving forward to that. And I think coupled with the fact and the statements from the Airport Authority as to the current state of the ground, boots on the ground, what's going on over there, is the appropriate way to deal with this dispute. We're talking about competing boards. That board didn't meet at the airport. It's not using the facilities of the airport.
The old board or the new board?
The old board's not. They met over here, which, we don't think it's a legally effective board anyway. But the proper board, the new board that's under this act, is engaged in business, doing what it should do in managing the airport.
But if this is effectively a summary judgment case and we have the fulsome record that we're going to have, because there's no need for discovery, likelihood of success on the merits, which is one of the factors we're supposed to consider, and of course we have to consider the other factors as well. I mean, don't we have all the information we need to make a determination about constitutionality? I know we're not at the final hearing stage, we're at the preliminary injunction stage, but there's nothing else to consider from a factual standpoint, right, or a legal standpoint?
Well, Your Honor, I would say in responding to that as far as any other details that may come out of the next few weeks could be germane to the court's ruling on a summary judgment, and this is a fluid situation. So I would say I can't give a categorical response to say, no, Your Honor, there's nothing else under the sun that would come up that could affect the court's ruling on the merits of this case at some point during a motion for summary judgment. I can't say that because I don't know based on the fluid situation. But what I can tell you is the state's not opposed to a very quick briefing schedule, scheduling order, so that the court can render a decision on the merits at some time in the reasonable foreseeable future.
Which we do appreciate, and I think that I appreciate the recognition that it needs swift determination, and that it's not in anyone's best interest, any of the affected parties' best interest, to drag it out and have a longer term of dispute or questions about who has the authority to do this. And does it make any difference? It's sort of interesting to me that the mayor has not appointed his two designees, and does that have any impact or significance in this, and that two of the designees who were appointed by the state appointing authorities were on the old board?
Well, Your Honor, this is a presumptively valid statute. Those two former members, they're members of this board, so that's the focal point that we look at it. But there's 6 of 8. They have enough on the board to conduct business.
Oh, and I wasn't questioning that. Yeah. I just wondered if it was relevant at all that this mayor had not appointed 2, or that 2 of the members were holdovers from the old board, or is that really not a factor that impacts?
I don't know what Metro Nashville's position is, but this is the only true board as our position under a valid statute. So what may have, the fact that the configuration of this board and the fact that it may have members from the old board is of no consequence to this action.
Doesn't the moment that this court issue a ruling, one way or the other, resolve the issue of 2 competing boards?
On the temporary injunction or
on the temporary injunction?
Well, I think you made a valid point about the FAA. I think if you render a decision denying the motion, saying that you feel like the statute's valid, or you grant it the other way, it's a signal to the FAA. I think from everything I've seen, they're in a holding pattern. So and so that's why I don't think having a case move forward without an injunction is going to affect anything.
I guess my question is, does this court have the ability to resolve the competing claims of who the true board is with the temporary injunction? Does that accomplish that goal regardless of how we rule? I think that it does, but I don't know.
Well, that would call for speculation on my part as to what the FAA official who wrote the letter was thinking. But I would think that if there's an adjudication in a court order, it may not be a final order, that it could potentially affect the way FAA deals with this situation. Thank you, Your Honor.
Thank
I appreciate
you
it.
so much.
One more thing. Were you thinking of anything specific when you said just a moment ago, this is a very fluid situation?
No, Your Honor. I'm just, when I said fluid situation, I'm talking about the situation of that, that there's this competing board that's saying that it has some authority to do something.
Has it taken some action that impairs the current board ability to manage the
None that I know of, Your
authority?
Honor.
Okay.
Thank you.
Thank you.
Thank you so much. Now we'll hear from the Metro Nashville Airport Authority.
Again, good afternoon, Judge Walden, Judge Hayes, and Judge Martin, Chancellor Martin. I represent the Metro Nashville Airport Authority. I'm here with Jim Murphy and Ryan Kilpatrick in that regard. A defendant in this action by way of a motion to intervene that was unopposed and granted by the court on July 13. The Airport Authority's motion to intervene, to be clear, was filed on behalf of the authority and the authority alone. We did not seek to intervene on behalf of the state. We did not seek to intervene on behalf of Metro. The authority is the sole owner and operator of the Nashville International Airport and John Tune Airport. The authority is run day to day by the president and CEO, Douglas E. Crulin, and a group of officers and other executive staff that have all of the expertise and all the subject matters required to conduct major airport operations. Day to day, the staff of the Airport Authority has helped lead and has led the phenomenal success of the Nashville International Airport that is touted so heavily in Metro's motion papers. All these dedicated staff want to do is run the airport. They just want to see this case to a conclusion and have a governing board, which is essential under state law. They want to get through this case. They want to run the airport. The authority intervened to make sure that as the court was considering any relief in this case, you had the opportunity to hear from the authority about decisions that could impact our operations, and I will talk about that. Based on the positions taken by Metro in support of its motion, and I say this respectfully to Metro, it is also important that the authority participate to ensure that the court is receiving accurate information about the authority's compliance with FAA requirements. When this legislation was first under consideration, the authority maintained the consistent position, which is still its position today, that it was staying neutral on whether the legislation was adopted. And when we filed the Airport Authority's motion to intervene, we made it clear that the authority was not taking any position on Metro's constitutional challenge to the vacating and reconstitution of the board under Section 2 of the Act. That is the Airport Authority's position. Nonetheless, appreciating the court's invitation for us to participate, it is necessary for the Airport Authority to be heard at this time, primarily for two reasons. First, to address, respectfully, Metro's mischaracterizations of FAA requirements as applied to the reconstitution of the board and Metro's exaggeration, in fact, I say it again respectfully, gross exaggeration of the alleged threat to FAA grant funding. Those mischaracterizations continue in the second declaration of Kirk Schaefer, which Metro filed with its reply. Mr. Schaefer offers a highly glossed over and misleading explanation of legislation that was before North Carolina and Mississippi and Georgia with respect to the airports operated in Charlotte, Jackson, and Atlanta, without explaining to the court any of the details that materially distinguish those matters from this one. The second reason why the authority needs to be heard is to address Metro's delay in pursuing a temporary injunction, which required that the authority seat the reconstituted board in order to comply with state law. And while, again, we do not take a position on the ultimate constitutional outcome with respect to Section 2, we do have to be heard that we believe that delay impacts the propriety of interim relief, a temporary injunction. There are therefore two corresponding issues to those areas that I would like to address. First, I will address Metro's argument that the seating of the reconstituted board threatens the award of FAA grants, which we strongly disagree with, and as I will discuss with the court ultimately, is just not true based on what's happened since the new board was seated. And second, I will address the disruption to the Airport Authority that would result from a temporary injunction. Now that the reconstituted board has already replaced the vacated board, the authority contends that the court should not attempt to somehow reverse course through a temporary injunction, but should do exactly what there was some discussion about during the last argument, which is proceed promptly to a final decision on the merits, and at that time decide whether any relief from the act is needed. Let me give you a roadmap of what I'm going to discuss with respect to the FAA funding threat, or I should say the alleged funding threat. The first thing I'm going to look at is the 2016 FAA policy. I'll try to be mindful of the fact that Chancellor Martin has indicated that the papers have been thoroughly read, so I'll try to be succinct, but I do want to talk about it. The second thing I'm going to address is the communications between the Airport Authority and the FAA regarding the legislation. We've covered it in our papers, but there's some things that I think bear emphasis. Then I will address Metro's suggestion that leaving the reconstituted board in place threatens FAA grant funding and the reasons why that position is respectfully erroneous. And that will include a discussion of Mr. Schaefer's second declaration regarding Charlotte, Jackson, and Atlanta. Now let me do a little unpacking of Metro's position, and let me talk about the details here because the details are important. Starting with the FAA's 2016 policy. which was a policy statement that the FAA issued in reaction to legislation that affected Charlotte, which I'm going to get back to. Metro misconstrues the policy. Ms. Roberge, during her presentation, conflated changes in governance with changes in sponsorship, which are two different things and which get very different treatment under the 2016 policy. The 2016 policy primarily addresses changes in an airport's sponsor. The sponsor is the entity that applies for the federal grants and agrees to observe the terms of the grant assurances, which we exhibited to our response. Relatedly, the policy also addresses applications for changes in an airport's operating certificate, because if you have a change in ownership, a change in sponsorship, a change in operating certificate typically comes with it. The title of the policy states that it addresses not disputed changes in governance, but disputed changes of sponsorship at federally obligated airports. The introduction states, this document clarifies the FAA's legal authority and policy for monitoring and approving requests to it change the, quote, sponsorship of and or operational responsibility for an airport from one public agency to another public agency where there is a dispute surrounding the change. And then, and again, I'll try to move forward as quickly as I can. When you get to Part 4 of the policy, it actually addresses how the FAA deals with disputes over changes in sponsorship or operating authority. It says that the FAA expects disputes about whether to change airport sponsorship and or operating authority will be resolved through a legally binding agreement between the parties involved in the dispute or a final non-reviewable legal decision. Part 4 also states that until such resolution, the FAA will not act on a Part 139 application or a change of airport sponsorship and or operating authority. As we discussed at some length in the brief, here there is no change in either the sponsor or the operating authority with respect to the Nashville International Airport or Tune Airport. As has already been discussed by everyone, I'll briefly recap. Metro created the Airport Authority in 1970 pursuant to the enabling legislation, which was the Metropolitan Airport Authority Act, and transferred to the Airport Authority the Nashville Airport and all of its assets. The Airport Authority actually paid for those assets, by the way, both by monetary consideration and assumption of debt. At all relevant times, the authority has been and remains the sole owner, operator, and sponsor of Nashville International Airport and John Tune Airport. Section 2 of this act does not change that. There is no requirement in this situation of an AA approval of a change in sponsorship because there is no such change. The Airport Authority also has not applied for and will not apply for a new operating certificate because it remains the sole owner and operator. There is no need for a new operating certificate, and at no time has the FAA suggested that one is required. That is unlike, by the way, to give you a spoiler alert, that is unlike what occurred in Charlotte, Jackson, and Atlanta, as I will discuss shortly. Now, there are other portions of the 2016 policy that encourage consultation with the FAA regarding changes that may impact an airport's governance. For example, the introduction, there's another sentence that says this document also describes the requirements for coordination between the FAA and state or local governments contemplating actions that may impact an airport's, and I'm paraphrasing, governance to ensure that such actions are consistent with federal requirements. Part 3 goes on to say, and by the way, this will come up in the FAA's first letter to the Airport Authority. It says any state or local legislative body or public agency considering legislation that would impact airport governance should request technical assistance from the FAA about the interrelationship between federal and state or local requirements and seek the FAA's review and comment as early in the deliberative process as is practical. Now, the truth of it is here, and I'll only briefly touch on this, this act does not change the governing body of the authority. It was a Board of Commissioners. It will be a Board of Commissioners. The only thing that has really changed is the number of commissioners going from 7 to 8 and the manner in which they're appointed. But there's really no change in governance in that sense. But moreover, even if the act could be deemed to impact governance in the way that the FAA maybe would have in mind or be concerned about under the policy, the reason why the FAA asks for coordination about governance changes is because it wants to make sure that there are no changes in governance that will affect, or I should say impair, the sponsor's compliance with the grant assurances. That's the contract, in essence, with the FAA that secures the release of the grants. The legislation here is not going to have any negative effect on the airport authority's ability to comply with FAA requirements, whether under the grant assurances or otherwise. The legislation changes how commissioners are appointed, but does not in any way diminish the authority's powers or its ability to meet its federal obligations. And so, in any event, at most, all the 2016 policy required is consultation with the FAA with respect to the legislation. That occurred here, and I will get to that. There's only one other portion of the 2016 policy I want to briefly touch on, which further recognizes the limited scope of the FAA's approval authority. In Part 2 of the policy, it says, while state or local legislative action or a judicial action, as the case may be, may seek to change an airport's ownership, sponsorship, governance, or operations, only the FAA has authority to determine sponsor eligibility, approve and formally change airport sponsorship, and approve and issue a new airport operating certificate pursuant to 14 CFR Part 139. So once again, the FAA is recognizing that all of these decisions can be local, specifically including governance. They are local. The only thing the FAA has to approve is a change in sponsorship or an operating certificate, which is not happening here. All of this provides context for the first letter from the FAA, which is its March 31, 2023 letter to Doug Crulin, which was exhibited by Metro in its reply as Exhibit 1. This is the letter in which the FAA, Kevin Willis of the FAA, basically notified the authority that, hey, we're aware of this proposed legislation, and then the letter cited to the 2016 policy, but it in no way suggested that the act would in fact trigger a requirement of some approval. The FAA didn't suggest there was going to be a change in ownership or sponsorship or a need for a new operating certificate. In fact, the first paragraph of the letter, what it stated was that the proposed change in the appointment authority could be viewed as a substantial change impacting the governance of the airport authority and both airports. Now, like the 2016 policy, this letter went on to recognize the limits of the FAA's jurisdiction in changes impacting governance. The letter states, only the FAA has the authority to issue an airport operating certificate, and I'm paraphrasing, or approve the transfer of federal obligations to an eligible sponsor, if applicable. They didn't say it was applicable here. The FAA said that is where our approval jurisdiction rests. The FAA also recognized, however, that who governs the airport is a local decision. And since the FAA indicated that the proposed legislation might impact governance, they didn't say it was going to impact sponsorship or ownership or operating authority, it only requested an opportunity to consult. If you look at the second page of the March 31 letter, I'm not going to read the whole paragraph, I'm going to paraphrase, but it concluded with, the FAA has questions regarding the potential impact of the transfer of the appointment authority of all board members from the mayor of the local community to state-appointed officials. Goes on to say the FAA would like to discuss the potential impact on the airport authority and the airports. The FAA looks forward to working with the parties to resolve all possible issues involving federal concerns or requirements. We are available to discuss these items at your convenience. They invited this consultation, this coordination. So what happened? The FAA sent that letter on March 31, 2023, which was a Friday. Mr. Crulin promptly responded over the weekend. Indeed, on April 2nd, a letter dated April 2nd was sent to the FAA, which provided the FAA with a current copy of the legislation. Again, it was only proposed at that time. And as Mr. Crulin correctly stated, the legislation is not going to result in any change in the airport's ownership, sponsorship, governance, or operations. Mr. Krulin noted the same airport authority was going to be the same legal entity operating the airport after the legislation passed, and that basically he said, we will continue to run the airport under the guidance of its Board of Commissioners appointed pursuant to state law. Mr. Krulin offered to make himself available to the FAA. The coordination was happening, and in fact, as reflected by Doug Krulin's declaration, which is Exhibit 3 to our response, Mr. Krulin and his staff had a video conference just 2 days later on April 4, 2023, with the author of the FAA letter, Kevin Willis, and others at the FAA. At no point during that conference did the FAA suggest that its approval was required for the change in appointment authority. The only thing that the FAA requested from the authority was, okay, send us a transition plan, your plan for transitioning to the new board. Mr. Krulin thereafter, as is depicted in his declaration and the exhibits, kept the FAA updated regularly updated on the progress of the legislation and provided copies of the orientation package to be used for transitioning the new board members onto the board. At no time in any of this did the FAA suggest that anything else was required from the authority, much less did it suggest that transitioning to this new board would somehow imperil the receipt of grants, much less, quote, violate federal law, which are some of the things that Metro has talked about during the course of at least public statements in this case. Then there's the letter from Associate Administrator of Airport Shanetta Griffin, in which Ms. Griffin stated that the FAA would purportedly continue to recognize the existing board until such time as the Chancery Court rules on the issue. The end of that letter states that in the event a new board is appointed pursuant to the court's ruling on the legislation, the FAA will require the newly appointed board to satisfy and honor the federal obligations the authority has with the FAA. Now, this was a letter that was sent on June 26, just 5 days before the Section 2 of the Act went fully into effect. Metro solicited this letter without checking with the authority, much less obtaining its consent or participation. It was not something the FAA issued on its own. Metro requested the letter via Mr. Dietz's.
But you had been invited to give input prior to it, because I'm looking at the letter. She references a letter that you wrote on behalf of the authority. So it's not like the authority was left out of the process.
All I'm pointing out, Your Honor, is that that is a fair statement in the sense that Mr. Dietz wrote a letter on June 15th. The FAA forwarded that letter to Mr. Krulin. Mr. Krulin, in turn, forwarded it to us, and we did have the chance to respond. That is fair. But all I'm pointing out is we didn't initiate a request to the FAA to somehow recognize the then existing board until the court ruled. That's the only thing I'm pointing out.
Oh, and I don't, at least my reading was never that. It was
Right.
very clear to me that Metro sought that and obtained the letter.
Right. I will say, I think that if you look at the June 26 letter, the FAA, in reference to my letter, mentions one of the reasons why we had intervened, which was to make sure that if and when this court ruled on a motion for temporary injunction, that it was clear there would be no uncertainty if the court enjoined the implementation of the act as to who is our governing board. If you're going to enjoin it, then who runs the airport in the meantime, or who manages its affairs? So the FAA picked up on that. My point is, Chancellor Martin, again, we did not initiate it, and certainly in our response, we weren't inviting it either. We were suggesting that there was no need for the FAA to intervene because it would be up to this court to determine as a matter of state law who would be the governing board while the case was pending. So,
Understood.
In any event, the FAA did not ground its recognition or purported recognition in any kind of legal authority. The FAA policy sets forth the FAA's official position that changes in governance are a local matter. I say respectfully to the FAA, but they don't have the authority to override or negate state law when it provides for a change in governance. And the June 26 letter doesn't state otherwise. The letter only really stated in material part that the purported recognition was to avoid any, quote, uncertainty as to the governance of the airport authority. Well, within a few hours of receiving this letter, my firm responded on behalf of the airport authority. We're now on the evening of June 26th. And we pointed out to the FAA that there was no uncertainty at that time pending a ruling by the court regarding who the governing board was. As we pointed out to the FAA, under established Tennessee case law, the act was presumed to be constitutional unless and until this court intervened and declared it to be otherwise. And so we stated there really was no need or legal basis for the FAA to send the letter. We suggested that if there was some legal underpinning, some authority, to please send it to us. And we clearly, unequivocally stated that the authority would proceed with seating the new board in accordance with state law, and confirm that the authority would at all times honor all grant assurances and other federal obligations. It's now been 32 days since the letter from the FAA and our response. The FAA did not provide any legal authority suggesting that this recognition was somehow grounded in some federal statute or federal law. The FAA did not dispute or question our explanation that pending a ruling by this court, there was no uncertainty about who constituted the board. The FAA did not say we should desist with proceeding with seating the new board. The FAA has not suggested that it is considering any investigation or enforcement action or other decision-making process as a result of the authorities being compelled to follow state law and seat the reconstituted board. And the FAA certainly did not suggest that it would substitute its judgment for this panel once the court convened and made a ruling, as Judge Walden earlier pointed out, a ruling on whether an injunction should be issued and who is actually in power at the authority from a board standpoint while the remainder of this case is pending. Now let me pivot and talk specifically about the alleged threat to funding, which is ultimately where Metro tries to point the harm, or the alleged harm, at least up till, particularly up through their initial briefing. In public statements over the past few weeks, Metro accused the authority of violating and acting in defiance of federal law by seating the new board as it was obligated to do under state law. I don't want to spend too much more time on this. We've made it clear in our papers. I don't really see Metro hopefully arguing otherwise. The airport authority has at all times in connection with this matter followed its legal obligations. It had no obligation under the 2016 policy, under any other part of federal law. It had absolutely no obligation and frankly no power or discretion to simply unilaterally or with the encouragement of Metro disregard an act that had been passed by the legislature. The authority had no choice to do what it did, and of course we cited a number of cases from federal cases where similar letters, including 2 cases involving FAA letters and other circumstances, where courts have held that merely getting a letter from an agency that is tentative or interlocutory or is making certain commentary or remarks is not enough to constitute a binding ruling or directive, and especially where you have a letter like this one that doesn't command the authority to do anything. I mean, it says the FAA is going to recognize the existing board to avoid uncertainty, but the authority wasn't directed to violate state law, and any suggestion to the contrary is just wrong. There are other reasons beyond the fact that the authority has always acted in compliance with the law, and the point there, of course, is the FAA has no basis to be taking any enforcement action, and it hasn't threatened any enforcement action. In its original brief, and I know the court has read this thoroughly, but I want to emphasize this. In the original brief, Metro, relying on Kirk Schaefer's first declaration, argued that the seating of the board might result in the FAA cutting off existing grant funding. I quote to Metro's original brief at page 46, in quotes, "Should the FAA determine that MNAA is ineligible to receive funds, all payments on current FAA grants would stop." The authority's grant obligations to the FAA are embodied in the grant assurances. When you really read Mr. Schaefer's original declaration carefully, he is very careful about not going places that he can't possibly go. For example, his original declaration said 2 of the grant assurances were implicated, but he never really explained how they possibly were violated here. And without going too far into the weeds, the two grant assurances were number 2 and number 5, and we discussed at some length at the brief as to why there is absolutely no violation of those grant assurances by virtue of the authority just following state law in implementing the new board. We also pointed out, and by the way, there's no dispute about that in the reply. The Metro did not come back and say, oh yes, there's a violation of the grant assurances, completely absent from their reply. We also pointed out that the FAA had not suggested that it would or even might commence any enforcement action under Part 16, which is the part under the federal regulations that drives that kind of enforcement action. No reply from Metro about that after we unpacked that and discussed it in our brief. We pointed out that even if the FAA did commence such action, this court would issue a final decision in this case long before any such case would conclude and result in any speculative hypothetical loss in funding. The case Mr. Schaefer cited in his declaration that he was involved in when he was in the FAA took 6 years just to get on his desk and for him to issue a decision. And oh, by the way, when Mr. Schaefer issued that decision in that case, he didn't pull the sponsor's grant funding. He basically said that we ought to have a corrective action plan to make sure the sponsor complied with its grant assurances. My point is, if you just look at the record of the case Mr. Schaefer handled, the FAA is not going out of its way just to punish sponsors by pulling grant funding, much less in a situation where an airport authority is just following its obligations under state law. Finally, and I've already made that point, so I'll move on. Metro's reply, again, did not respond to any of that. Instead, if you really examine their reply, we're off of the idea that existing grant funding is going to be cut, and we're onto this idea that the FAA might not award any new grants while the lawsuit is pending. Well, that's based on Mr. Schaefer's second declaration, which, like the first, leaves out a lot of important details. Metro cites Schaefer's second declaration for the proposition that in all other instances involving disputes over governance and control, the original board remained in existence and continued to receive grants from the FAA. And the instances that Mr. Schaefer was citing to was Charlotte and Jackson, with also a passing reference to Atlanta. Again, here's what the declaration didn't tell you, didn't mention at all. The legislation at issue with respect to Jackson, Mississippi, and the Jackson International Airport created an entirely new entity to own and operate that airport. Specifically, the legislative act provided for the abolition of the existing Jackson Municipal Airport Authority and established in its place a new legal entity, the Jackson Metropolitan Area Airport Authority. It was a change in the legal entities owning and operating the airport that required the FAA's approval in that situation and a new operating certificate, not going, as Mr. Schaefer would have you believe, simply going from an old board to a new board. It was going from an old operator and sponsor to a new operator and sponsor. In the Charlotte case, guess what? It's the same thing. Mr. Schaefer doesn't mention in his declaration that the legislation at issue related, involved in that case also involved the creation of a new entity to own and operate the airport. The North Carolina legislation, which was called the Charlotte-Douglas International Airport Commission Act, created the Charlotte-Douglas International Airport Commission. And under that legislation, the new commission was given the power to operate the airport. So when Mr. Schaefer states that a state court judge enjoined that law to allow the FAA to weigh in, it was in the context of there being a need for the new entity to receive an operating certificate, whether a new one or by transfer from the old entity, in order for the airport to function. The other thing Mr. Schaefer doesn't tell you is that a temporary restraining order was issued by the North Carolina Superior Court, barring enforcement of the law before it went into effect. Indeed, the very same day that the relevant Senate bill was approved on a final vote, this is even before it had passed the entire legislature and been signed by the governor, when the relevant Senate bill was approved on a final vote, the city of Charlotte filed a verified complaint and motion for temporary restraining order and preliminary injunction, and a TRO was issued before the law went into effect, and that is not what happened here. Metro did not do that. And in fact, both Jackson and Charlotte involve situations where the affected cities sought preliminary injunctive relief before the changes provided by the legislation became effective. They have nothing to do with the situation. Atlanta, he only mentions in passing, and that's because the Atlanta legislation didn't even actually pass. It's got hung up in the legislature, I think on the House side, and it has not been passed. But in any event, if it had any relevance at all, guess what? Same thing. It contemplates the creation of an entirely new entity to own and operate the airport. It's in that context that the things that Mr. Schaefer talked about occurred. The last thing I'll say about his declaration is that in the second declaration, Mr. Schaefer concludes that he is not aware of the FAA ever having issued a grant to a potentially illegitimate board. And, Your Honors, that is pure smoke and mirrors. The FAA does not issue grants to boards. They issue grants to entities serving as sponsors. Moreover, while Mr. Schaefer states that he's not aware of grants being awarded to potentially illegitimate boards, his declaration does not identify any instances where the FAA has refused to issue new grants for an airport based on the circumstances actually at issue here, specifically where the governing board for the entity owning and operating an airport has been vacated and reconstituted based on state law. So when Mr. Schaefer says, I'm not aware of grants to potentially illegitimate boards, he's offering a purely contrived conclusion based on the absence of any relevant examples. Not something to rely upon in deciding this matter. There may be other things to rely upon, but that's not one of them. There is no threat of fiscal harm to the airport authority related to FAA grants. In sum, any potential harm here is entirely conjectural, and frankly, because the authority has done nothing to violate its grant obligations, has acted in accordance with state law, has dutifully done so, there would be no basis for any kind of enforcement action.
I have a quick question on that.
Yeah.
As our chief judge pointed out, this has only been in effect for about 5 minutes. And I don't know how often this grant money is dispersed, but in the past 28 days, has the airport authority in fact received any funds from the FAA?
Well, that's exactly where I was going to go next, Judge Walden. And so, yes, the answer is yes. Since the seating of the reconstituted board, the airport authority has continued to receive funds for existing grants without any issues. 3 times since July 1. 3 times the authority has received draws on existing grants. July 5th, July 18, and July 19, the authority received draws on current FAA grants, no interruption whatsoever. But there's more than that, Judge Walden, which is just this morning, in a conversation with the FAA's district office in Memphis. The authority's president and CEO, Doug Crulin, learned that the FAA is going to award the authority a $6.4 million grant as a discretionary grant under the FAA's Airport Improvement Program. Let me emphasize, discretionary grant. The Airport Improvement Program includes so-called entitlement grants that are based on certain metrics related to passenger and cargo volume. But discretionary grants are just that. There's no guarantee you're going to get a discretionary grant, and yet that's exactly what they're going to get right here on the morning of this hearing.
And it probably goes without saying, but I assume there wasn't an anticipated disbursement that wasn't received.
That is correct, none whatsoever. And so when Mr. Schaefer's speculation about a threat to new grants, it's not merely wrong, it is demonstrably and emphatically wrong. It's just not right. And one final point here, and I apologize if I'm approaching the point of overkill on some of the reasons why there's no real threat to grant funding, but the court also ought to have some perspective on the relative importance. And I am not suggesting that the authority is not grateful for every dime they get from the FAA, but when we talk about some impact on the fiscal stability or life of the airport authority, you know, as Mr. Simons pointed out, the airport authority is still running the airport. The planes are taking off. Everything is going well. But beyond that, the court needs to understand that the FAA's grant funding is actually a very small percentage of its overall capital expense budget. For example, in fiscal year 2023, FAA grant awards were a mere 6.8% of the airport authority's capital improvement budget. Most of that was actually under a temporary grant called under the bipartisan infrastructure law. The award received under the FAA's regular recurring program, the Airport Improvement Program, was a mere 0.8% of the capital budget, less than 1%. And as far as the authority's overall financial health, please consider its remarkable liquidity. As was reported in one of the recent board meetings, as of March 31, 2023, the authority had $1.2 billion in available operating funds. That's $1.2 billion with a B. And if you include the 4 primary reserve accounts, the authority, as of March 31, had 829 days of operating funds. That means as of March 31, the airport could continue operating for 829 days without any other dollars coming in. So this suggestion that the sky is falling and there's this threat to funding and it's going to all of a sudden create all these problems is just entirely baseless. The final thing I'll simply say on the June 26 letter, and then I do want to talk at least briefly about the disruption concern, is that really ultimately, I know I've spent a lot of time talking about this because I think it's important to make sure we unpack the reality of how where the airport stands with the FAA and where it stands regarding its grant funding. But even if the court is left with any lingering concerns about the FAA's June 26 letter and what it means, it should just proceed to decide Metro's motion without regard to the letter. The letter is effectively moot now. All the FAA said is we're going to recognize the existing board until this court rules. This matter is now before the court for a ruling. Whatever it meant, whatever its significance, whatever we want to debate about it, it really doesn't matter. This is in the jurisdiction of this court. This court is supposed to decide who governs the airport authority. It is not within the FAA's jurisdiction, and we certainly have satisfied any collaboration, coordination, consultation requirements or expectations. The final thing I'll say is, and look, let me emphasize, ultimately, however this constitutional fight turns out, we're agnostic. We just want to get back to running the airport. We want this case to get to a final conclusion, but the airport authority does have to respectfully express the concern, which was covered in our papers, but I do want to talk about it, which is the delay which has in turn resulted in the airport authority seating the new board and the disruption that could occur if you try to unseat it on a temporary basis. If Metro was so concerned about the impact of the grant funding, why did they wait 24 days to file suit? Why did they solicit the FAA to recognize a soon-to-be vacated board, wait until the eve before the act became effective to seek injunctive relief, and then accuse the airport authority of violating federal law, and then encouraging members of the vacated board to have a meeting over here in the courthouse to create, and I say this respectfully, but this is the fact, to create the illusion of there being 2 competing boards. There's only one valid board after July 1 until this court says otherwise.
Has the airport authority experienced any issue where the prior board is trying to exert contrary directions to the authority or competing instructions?
The answer is no, Judge Walden, but what I would urge the court to consider, particularly given the heat surrounding this matter and the fact that now I'm here and the authority has been pulled into having to participate in some of that heat because we've got some things that we want to say here. But I guess what I would say is while no, there's no instructions being issued, and frankly, I say this respectfully, the meeting that occurred here at the Metro Courthouse, I don't think it meant anything other than simply being sort of a publicity stunt. I don't think there was any meat to it at all. There certainly wasn't any, anything related to the airport authority or its operations. But what I would say is that having this illusion, this story about there being 2 competing boards, it is a reputational issue. It creates mistrust in the public eye. Does that have any long-term effect? Probably not. But in the short term, while this matter is pending, when you've got all these stories out there and statements being made to the press about there being 2 competing boards and the airport authorities violating the law, I do think that has some damage, at least in the short term. I do. But no, it has not caused any interference as a practical matter with the execution of the authority's affairs. No. So I'm not going to go back through whether the delay. I mean, look, the bottom line is, I think that under the authorities that Metro has cited, they say at page 25 of their reply, the point of an injunction is to avoid irreparable harm, not wait for it. They say at page 22 that where constitutional rights are threatened or impaired for even minimal periods of time, irreparable injury unquestionably occurs. Well, the threat, and I would say actually the alleged injury, constitutionally happened when Governor Lee stroked his pen and signed the act into law, because at that point the approval authority or the appointment authority was transferred until a court basically said that that was an unconstitutional transfer. So I don't really think that there was any reason to wait, and I respectfully would suggest that the assertion that there was some misapprehension that the airport authority or the state was going to sort of, quote, follow the 2016 policy, whatever that means, I just don't think that's really fair, because in Mr. Crulin's response to the FAA's March 31 letter, he made it clear that, look, if the legislation passes, there's no changes in operating authority, there's no changes in sponsorship. We will continue to operate the authority. He didn't send any signal that that basically the authority was going to flout its obligations under state law, and I don't know that the state sent that signal either. I'm not aware of it. And the assertion that Metro held off on seeking a temporary injunction because it thought the parties would follow the FAA's recognition of the vacated board also makes no sense. And Judge Walton, again, I return respectfully to the court. I think you made a reference to this in some of your earlier remarks, which is when the complaint was filed on June 15th, there was at least a prayer for a temporary injunction. There was no reason to wait. Now, I would submit that there was no reason to wait to June 12th to file the complaint in the first place, but certainly there was no reason to wait on this recognition letter that had been requested. Look, it made no sense to wait, and instead, by waiting, what it did was it left the airport authority with no choice but to follow state law. The state act is deemed to be constitutional. Metro couldn't possibly have thought that somehow the airport authority had the power, the discretion, or the right to simply disregard state law. And that's our position. Now, as far as the disruption, certainly this two competing boards, respectfully, nonsense needs to stop. There's no two competing boards. This court needs to issue a ruling that certainly clears that up and determines who the governing board is. There's not two. There's one.
Mr. Cate, do you agree with the Attorney General's office that this is a summary judgment case, that we could put this on an expedited schedule, that no discovery is necessary, and get it positioned for a final decision pretty quickly?
And Your Honor, that was where I was ultimately going to close right now, which is why are we going through this? Why, having waited till the law became effective, are we now trying to somehow roll back the hands of time and undo and whatever, reverse course? Yes, Your Honor, I'm not aware of any discovery being needed. This case ought to proceed on an expedited track. I think that's what's happened in the so-called Fairgrounds case, which is the case that basically addresses a state law that changed the requirement of the Metro Council passing certain legislation by a supermajority, which also covers the issue of a new racetrack at the fairgrounds. I think that's due to come up before the council in early August. And it's my understanding, Metro filed with the support of the state, filed a motion for expedited proceedings and got that on motions for summary judgment this month. Why are we here talking about a temporary injunction? We ought to be just getting to a conclusion now that the delay has gone to the point that the new law has already come into effect. And just briefly, I don't want to, look, here's the bottom line. Trying to unseat the board, Ms. Roberge made the point that, well, the new board has had 2 meetings. It's actually had 3 if you include the committee meetings on July 12th. There's a total of 3 meetings they've had, but that's not the point. The point is, regardless of the number of meetings, you have new members of a board who've been onboarded, who've been oriented, who are in place, and who are doing the business of the authority. I don't even know, and I have to concede, I shouldn't say me, it's Brian Kilpatrick. Mr. Kilpatrick and I did not find any cases under Tennessee law that directly address this, but I don't know whether it's really practical for the court to try to bring back the old board, so to speak, or the vacated board. And I would point out that Metro is already, in our view, upset the pre-act status quo anyway, because their position is that Commissioner Granberry and Commissioner Jocelyn have resigned from the vacated board, and apparently Metro is contemplating appointing 2 new board members, I guess, if this court basically rules it's back in place. And now you got 2 new board members who they've got to be onboarded now. And I guess the last thing I would say is just because of the circumstances and what's gone on over the past few weeks and statements that have been made about the authority and its staff, does it make sense to have the Metro appointed board back in place while this heated litigation is still pending? Shouldn't we get to the end of this case, get a ruling on the merits, and then make a decision as to what relief is required? And by gosh, if we get to the end of the case and the court makes a reasoned ruling on the constitutional issues, as we know the court will, the authority will live with that. You just want to operate the airport. Do not impose on the airport the cost of dealing with the disruption that would be caused by some interim relief. That is our respectful position. And if I can have one moment. That's it. Unless there are any other questions, I appreciate your patience. I know my talk was lengthy, but I appreciate you giving me the time to do it, okay?
Thank you.
Thank you.
Ms. Roberge, how much time do you need to reply? I'm trying to decide whether our court reporter needs a break and my colleagues and I need a break
How
before we
much time,
finish.
really?
I will try to be less than 15 minutes, but I'm also happy to take a break.
You all need a break? Or
Take a break.
We're going to take a quick break. It is 3:25. We'll be back at 20 till.
All right. Please be seated.
All right, we are ready to proceed with Metro's rebuttal.
Thank you, Your Honor, and I will be brief. Everyone is seeking clarity, and that court can do that by ruling on the temporary injunction motion. The factors that are set out for a temporary injunction are just that, factors. The higher the likelihood of success on the merits, which the arguments here today make clear that Metro has a high likelihood of success on the merits, the lower the harm. And better to reinstate the Metro Board that is ready, still attempting to conduct business, and hasn't gone anywhere. They don't need onboarding. They don't need any extensive new training. They've done this before.
If
But-
the motion is denied, though, does that end this idea of competing boards?
Your Honor, it's my understanding that in their board meeting last week that the board requested legal counsel, and so I don't know what their legal counsel may advise.
I did read about that in the paper, that there was discussion about additional legal counsel. I don't know what that meant. Mr. Cate seems to be holding his own with Mr. Murphy, and Mr. Kirkpatrick just fine. So I wondered how that was all going to sort itself out.
This would be counsel for the Metro appointed board.
Oh, okay, okay. That makes sense.
But if there is a ruling from this court that the law is not temporarily enjoined, doesn't that answer that question?
It would
Who
depend.
governs Metro Nashville Airport today?
I think it would depend on the grounds for that ruling. If the grounds is that that they're, because of reasonable promptness, the court isn't reaching the likelihood of success on the merits, I don't know that that would end this tension. What would end the tension is a decision on the merits, or the likelihood of success on the merits.
And I will tell you, we are going to enter a scheduling order and get this set. And we've looked at dates, and rather than check with all the fine lawyers in the room about their schedule, we're going to ask you all to work around our schedule, because these judges have to come from districts that have multiple counties and courthouses and dockets. And we're going to do it on a Friday, because for them, that's the easiest day to travel. And we'll probably do it a Friday afternoon, because that just seems to make sense.
And we agree with the state that this can be decided on an
I
expedited
meant
basis.
to ask you that had been the position of the other parties, and we wanted to make sure that Metro agreed as well.
We do, Your Honor.
Okay.
You talked about the qualifications of the Metro appointed board and said they're ready and willing. Isn't the reality that two of those members that have been in these meetings and been trained and onboarded, they're on the new board? And could harm be mitigated when we consider that two members that were appointed by the mayor are on the new board, and the mayor could appoint two more today? That would constitute half of the new board being the same membership from the old board. Does that at least mitigate it? It may not mean there's no harm, but
I don't know
mitigates
that
it some way.
it necessarily mitigates it. The mayor hasn't made any indication that he intends to appoint to this board.
But he can if he wants to,
he
just like
could.
everybody else has.
Correct, Your Honor. But it's more harmful, and the injury to Metro's sovereignty still exists when the representation on the board of its agency and instrumentality is split. And so we would ask that this court enter a ruling on the likelihood of success on the merits for the temporary injunction. I want to go through just very quickly local form and effect. There was a question about the role of legislative history. Legislative history can be considered and used to confirm this court's understanding of the plain language. Here, the plain language dictates it only applies to Metro. There was a concession of counsel that this was designed, and the rationale was solely the BNA airport. And then you have the multiple statements, including by the bill's sponsor. Chancellor Martin, I believe you asked the question of who would want to grow into this statute? And the answer is nobody. Who could grow into this statute? The answer is also nobody. There's,
At least until 2030, or whenever those census results are released from 2030.
well, no, they couldn't because of the provisions in Section C. Those work as deadlines, and that first deadline is in 2025. Because after that, there's no provision in the statute for when the governor's appointees, when their initial term would end. Even still, the state...
You mean if there was another authority, or if there was another authority that somehow came under the statute because it couldn't possibly have terms consistent with subsection C, then it couldn't happen.
Exactly, Your
Okay.
Honor. And the state focused on Shelby as the only other government that even has an extreme long shot of joining this class. But Leach says that 2, and only ever 2, is still local in form and effect.
Of course, we're talking about something that can at most only affect 4 counties anyways.
Correct, as it stands right now.
So should that 2 threshold still apply here when we're really looking at a class of 4? And respectfully, there is a huge difference between both the Nashville and Memphis airports and the Knoxville and Chattanooga airports.
2 should still apply here because it's really still only 1. The chance that Shelby would join is so remote to be illusory. It would need to consolidate with the city of Memphis, and that's not a process that happens overnight. And they would only have 2 years to do that. Ferris said that they wouldn't try and predict the General Assembly, but to decide that Shelby could possibly grow into this act, this court would need to anticipate that despite knowing that the economic driver of its county would be taken over by state officials, that the city of Memphis would decide to consolidate, that the county of Shelby would decide to consolidate, and then the electorate would approve that. Predicting all 3 of those things is at least as difficult as predicting what the General Assembly would do in any subsequent years. There was a suggestion by the state that this court allied to Section 3, but that makes it inoperable. Chancellor Martin, as you pointed out, if Section C doesn't exist, there's no provision for the initial terms. So you cannot just take an axe to Section 3. Finally, Your Honor, Judge Walden, I wanted to return to your questions about why the injunction is focused on Section 2. The other sections don't have the same timeline requirement, which is why we chose to focus on Section 2. Briefly, also on equal protection, the flaw in the state's argument is that the form of government has anything to do with how an airport authority runs. And to accept their premise, the metropolitan governments are so good at solving problems, except the problems of their airports. But we actually have history that shows the boards appointed by a metropolitan government do a wildly successful job. We would ask that you issue the temporary injunction because Metro Nashville has a high likelihood of success on the merits on all 3 of its claims, that this statute violates the prohibition on Ripper bills, that it is a statute that is local in form and effect without local approval, and that it irrationally creates a class of 1. Thank you.
But one brief question, and it came up based on the discussion about the prior board is seeking counsel. Are they seeking to intervene? Is your office involved in that? Are they going to seek to intervene in this, and will that affect our briefing schedule?
I'm going to let Director Dietz answer that question.
We can hear you, but we want to make sure that all of the watchers get to hear you as well.
Of course. Thank you, and thank you for the question. The board has said that because the state-appointed board has independent counsel, they believe that it's in their interest to obtain independent counsel. Obviously, they did not try to intervene to appear at this hearing. They had no intention of pushing this hearing off or adding any delay to getting a decision, which is what they want. But they believe that because they do not have the general counsel of the airport authority, who's in this room, they do not have independent counsel, that they need legal counsel of their own as a board. And so nothing has happened on that yet. And certainly there's the possibility there would be a motion to intervene, but that board does not want to slow down the deliberations in this case for 1 day.
What we might do is, in our scheduling order on summary judgment, put a deadline for any other party that wants to intervene and participate in that process to do it by a particular date, and then a corresponding deadline that is pretty quick turnaround for the parties that are already in to weigh in on that motion. We were able to go ahead and do an order allowing intervention and allowing the Port Authority to participate, and that would be our goal as well if an appropriate party sought to intervene, and it wouldn't be slowed down by having to set the motion and have it heard and so forth.
I agree. Have they retained counsel?
Pardon me?
Have they retained counsel at this point?
They are in the process.
They were granted the authority, I guess, by the council to get legal counsel, right?
Well, they assumed they had that authority.
Oh, okay.
There has been no action by the Metro Council to give them that authority. They assume, because in their mind, they are the governing board of a separate entity. They just thought they may want to have separate counsel. I'll say this. I would encourage the court, if it goes down this path, to keep those deadlines really tight because, again, the Metro appointed board wants a resolution on the merits of this claim, and that's the most important thing.
And I wasn't implying they had to get some sort of permission. I was really probably repeating what I thought I read in the newspaper. But regardless, we'll go ahead and put down a scheduling order, and we will address the intervention. So we are going to take this under advisement so that we can issue appropriate findings and conclusions as to the pending motion. That may take us a couple of days, but we will get our scheduling order down on Monday. We've already conferred, and I'm going to take care of that on Monday.
Excellent.
Thank you,
Your
all.
Honors.
What excellent arguments and presentations.
Thank you.
Did you have something, Judge Hayes?
No, I'm good.
It was a pleasure meeting you all. Of course, thank you, Chancellor Martin, and to the Metro Courthouse staff for their hospitality to Judge Hayes and I. We were talking about how well we were treated, and we enjoyed being here.
They're from small jurisdictions with just a limited number of them, so it's sort of nice to be together working on this. Thank you all.
All rise.